From distant lands we gather, hearts of fire all along. Open because we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Open because we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, 'cause we follow, through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Hey yo folks, and welcome. It is Wednesday. It's Wednesday. And we have, there's development. There is development in this trial. Now, for you who are here, you know, we are a half a day behind. So this took place Tuesday afternoon. And I have only seen a couple of minutes. But those couple of minutes that I saw, okay. This could potentially put spin on this trial. Potentially. And not so sure if that is in such a good way for anyone involved. Hey Amanda. Hey Gwendolyn over at YouTube. Hello folks over at Rumble. Let's check here if I have to check something. Yeah, live on Rumble. And hello at X. Yeah, streaming on three platforms. There's something off here. Oh. So, I'm for you who are completely new. What's this case? It is Texas versus McIntyre. Mr. McIntyre is also known as Tay-K 47, Texas-born rapper who was 16 back in 2017 when this capital murder case with the murder of Anthony Saldivar, who was fatally shot outside of a Chick-fil-A. And we are still on cross-examination of Miss Reyes, who will walk free after she testifies in this trial to the satisfaction of the prosecution. So and if you were here yesterday, you know my opinion about what I believe actually happened, because what has been during the cross-examination, you are the one who met with Mr. Saldivar, and you met him with 3 more guys And Mr. Saldivar did not know there were supposed to be other guys. And it seems like it's more of a setup, to be honest. It sounds like they were setting this guy up. And not so sure if Tay-K, sorry, not so sure how much he actually knew what was going to happen. But everybody is now pointing their finger at him. And here we are. And here we are. We are also at 27 sidebars and 10 motions for mistrial. So that is where we are now when we will start day 6. Hold on to your breechers. Do I believe her tears? I don't know. They are very, let's just say they are very, very convenient. Let's just say that. But, see here, playing 1.25 speed. And closed captions are on. And Linda says, nice outfit. Oh, thank you. Thank you. So yeah, let's get right into it. This, folks, you don't want to miss this.
All right, on this case,
Not as,
that's okay. On this case, on Mr. Baker, he has a medical emergency. Yes. Counsel? Are you going to be available, you think?
Sure. Just want to see. It's not pain. As long as it's going on. It's not.
All right, you,
okay.
if you want to, if you're available, I can recall it for tomorrow, but you'll need to be here exactly. It's here for Baker. All right. So, all right.
There's a whole bunch of them. I'll just wait.
All right. Well, you want to talk to him and see if we can talk to them and tell them what
It seems like she's talking. My apologies. This, sorry, at 1:30 p.m. So it was an afternoon session. So apparently this is on spillover from the morning session.
your issue is.
But the parties are almost all there.
And are all the jurors here?
I don't know. The bailiff's not.
Why not? Because he doesn't have the buttons
Yeah.
yet for it, so.
Yeah. He says that we were already. I don't want to. This is just a blue.
Okay. All right. Okay.
Leave that. Oh, wait, no, that's not hers. What photograph is attached to here?
Yeah.
Printed that.
Oh, it's right here.
Deputy Laura, can you see if everyone is here? Oh, that's fine. I just want to see if the jurors are here.
Where's it?
About what? Well, be without them.
Are those blue?
Yeah.
I need them.
Are you gonna eat this one?
Right.
And I'm gonna need all those files, Dorman, that I said I was recalling. Oh, Jenna, you're there. Thank you. I can't see. Everybody see? Okay. All right, as soon as he comes out, then we'll take it up.
Thank you.
She just.
Okay, let's skip ahead till. There you go. Jury is coming in. Witnesses on the stand.
All right, you're still under oath. And if you could just restate your name for the record, please. All right, make sure you keep your voice up so that members of the jury can hear. All right, defense, I believe it's still your witness.
Thank you, Your Honor. All right, Ms. Reyes, when we left off yesterday, I had asked you if you had previously told the detective that you knew that Mark getting into the car had the intention of having sex with you. Do you recall that question?
No, sir.
Okay, well, let me ask you again. When Mark got into your car, you knew that his intention was to have sex with you, right?
No, sir.
But that's not what you told the detective, correct?
No.
You had an opportunity to review your video yesterday after court
Yes, sir.
in its entirety,
Yes.
okay? I'm gonna call your attention to about 50 minutes and 39 seconds into that. Mr. Lane, if you could get that queued up for us.
So she actually reviewed her statement with the officer and still says she didn't say what she said.
Two questions are all over. Okay, so everybody had two questions?
The ones that was normal was mine,
We can go on.
but because they had vibrating toothbrushes, the ones that like.
So the vibrating ones, are they-
Perpetrators.
Okay, all right. I know it's gonna be kind of a stretch for you to remember, but you said that the guys are wore condoms?
Yeah.
What
I
color?
didn't look back.
Did you see the roll?
I didn't see it.
Did you see the lube?
I didn't see none of it. They just said it.
So what did they say?
They just said, they just said, or were you trying to rape her and this and that? Or maybe I think Taymor showed me the roll of condoms, but that was it. Like, I don't know if they're logical, I can't remember, but he was just like, were you trying to rape her and this and that, and that was it. And that's the only
Let me ask
thing.
you, do you think the dude had some condoms in his backpack? Sure.
No, he just thought he was in a book. That's just, that, of course, men, some men. That's of course some men, like, I didn't think that far into it, but that, that was just, like I said, I never looked back, I never looked to the side, nothing. I was scared.
So you told the detective that he thought he was gonna fuck, right?
Because he was interpreting that.
I'm asking you that you interpreted him as having interpreted he was planning on having sex with you, correct?
Because he said that.
And you saw that there were in fact condoms in the man's backpack after this was all over,
I
right?
never saw anything that was in the backpack.
You heard the portion where you said that Taymor showed you the condoms, right?
Yes, but I didn't see anything else that was in the backpack.
And the reason why Mark thought that he was going to have sex with you is because that's what you led him to believe, correct?
Speculation, she testified to what?
There's nothing speculative about what you previously said.
Approach.
Uh-oh. Prosecution objected, and the defense kept asking questions. We all know George Boyd isn't having that. We all know she's going to, nope. And sidebar counter 28. Sidebar counter 28. This is going to be wild, folks. This is going to be wild. There she is explaining, probably, to the defense. You heard there was an objection from the prosecution. Why did you keep talking?
So, defense, ask your question and then state, if there's an objection to it, you can make your objection. And I'll give the defense a chance to respond to that objection and I will make a ruling. So ask your question, defense.
Mark thought he was going to have sex with you because you had led him to believe that's what was going to happen that day, right?
No, sir.
Objection. Speculation.
All right, the objection, the witness has already answered. Ask your next question.
Thank you, Judge. Yesterday, to recap, we talked about the fact that Mark had tried to contact you on Instagram some time back before this incident, correct?
Correct.
And he had contacted you, right?
Correct.
And that resulted in you blocking him from your Instagram account, right?
Correct.
Because his account was largely pornographic in nature, right?
Objection. That's been asked and answered, and speculation.
All right, that'll be, the objection to asked and answered will be overruled.
You can answer the question now.
Correct.
And after you blocked him, you created a different Instagram account, correct?
Yes.
In fact, you've created several different Instagram accounts over the years, right?
No, sir.
You've only created one new Instagram account?
I believe so. I'll change the username for my safety, but I only have one other account.
Okay, but so you've changed the username multiple occasions, right?
Yes, sir.
A stripper with Instagram. What? Wild speculation without violating YouTube's terms and condition. What kind of pictures do you think was up there? Wild speculation. Would it be not child not child friendly pictures? Let's just say that.
And so you eventually, through a different username, made contact with Mark again, or he made contact with you? Which was it?
I messaged him.
Okay. And you discussed doing a photo shoot, right?
Correct.
And you and he asked you about doing the photo shoot in lingerie and underwear, right?
Correct.
And you advised the detective of this fact and the fact that you knew that that was the kind of photography he was into, correct?
Correct.
And so when Mark showed up at the car, he was surprised to see that there were all these other people in the car besides you, right?
No, sir.
That's why he called off the photo shoot, wasn't it?
He said he had to reschedule because he had another person.
But he didn't text you that, did he?
No.
He told you that in person inside your car after you all had driven to pick him up for the photo shoot, right?
Correct.
So the only thing that had changed between the time that you talked to him before and the time he got in your car was that there were 3 dudes in the car with you, right?
Can you say that again?
The only difference between when you arranged for him to meet you for this shoot and when he got in the car was that there were 3 dudes in the car, right?
He knew there was people there.
Let me ask you a question.
Yes, Mr. Attorney. Well, before you ask, I mean, defense attorney is correct. There is no text where she tells this photographer who then became the victim that there will be 3 more guys in the car. And then no text whatsoever, but he told her, let's reschedule. Yeah, I'm not so sure that is what was actually being said in the car.
May I approach, Your Honor?
Yes.
I'm going to show you what I marked as Defendant's Exhibit 10. Do you recognize that photograph?
Yes.
Who are the people depicted in that photograph?
My ex-boyfriend?
And you?
Yes.
object to relevance, Your Honor.
All right, if I could see,
Foundation.
if I could see the exhibit, please.
Can we see it? I have a inkling that that picture might not be fully dressed. Is she on only? I don't know. I do not know, Gigi. Yeah, Konsaki, not safe for work, I would believe, is the correct term for her Instagram or former Instagram account. And what happens when Judge Boyd does this with her Zoom food is she's discussing with the parties what's going on. So at this point in time, I believe this counts as a sidebar counter number 29. We just started day 6. Her testimony about the things that happened in the court is pretty much hearsay, or am I listening to it wrong? You're not listening to it wrong, but since she is also charged, or was charged for a crime, now she has pled out. She is a party in this case, which is a hearsay exception. But she still can't say what other people said. She's not happy.
Who is Rashard Horace?
I was working.
You were dating Mr. Horace in roughly 2018 until 2021, something like that?
Objection, relevance.
Sustained.
How long were you dating Mr. Horace?
Objection, relevance.
Sustained.
Did you spend time with Mr. Horace after the date, after April 23rd, 2017?
Objection, relevance.
That will be
Your Honor,
overruled.
I have to be able to ask
I
her.
said the objection is overruled.
So you spent time with Mr. Horace after the offense date of April 23rd, 2017, right?
Correct.
And it was a lot of time, correct?
Correct.
You actually at one point moved to Houston to be with Mr. Horace, correct?
Correct.
And during that time period, you discussed aspects of this case and your involvement. Do you recall that?
No.
Did you tell Mr. Horace that
Objection, calls for hearsay, both hearsay and improper impeachment.
it's not improper impeachment? Under 613, I have to confront her with the substance of her prior statement.
Objection is sustained.
You need to lay the foundation, Mr. Defense Attorney. Hey, Dave's here with a $2
You
super
testified
chat.
a moment ago that Mark knew that there would be men in the car with you, correct?
Correct.
But that is not what you told Mr. Horace, is it?
Objection, hearsay.
That'll be overruled.
That is not what you told Mr. Horace, is it?
I never told him anything besides that I had a case.
You never told Mr. Horace that you intended to get Mark to come for the photo shoot alone with you?
No, sir.
Now, you testified previously that you did not.
Now, I believe that the defense might have a surprise witness when it comes to their case in chief. Let's just say that. And thank you, Dave, for your $2 super chat saying, "Good morning, let's feed the algorithm." Yes, please do. And you don't have to do it with super chats or gifted memberships. As long as you are active in the chat, give me the thumbs up and subscribe if you are not yet subscribed. But yeah, it seems like the defense has at least knowledge of a witness, because they wouldn't say this unless they had interviewed her ex-boyfriend. Uh-oh, cocaine stripper. This is not good for you. This is not good for you.
Know Mark except as an acquaintance on Instagram, correct?
Correct.
But that's not what you told Mr. Horace, is it?
That is not true.
You've told Mr. Horace that you've known Mark since high school, right?
No, sir. I knew him because of high school. He was older than us.
That's what I'm asking. Because of high school, you knew of him?
Of him, correct.
And you also told Mr. Horace that he had tried to violate you on a prior occasion, correct?
No, I did not.
And you also told Mr. Horace that you didn't tell Mr. McIntyre or any of the other people in the car about this past interaction with Mark before getting in the car with him that day to pick him up, right?
No, sir.
And you also didn't tell Mr. McIntyre or anybody else that you secreted a gun underneath your seat in the car when you went to go pick him up that day, right?
That is not true.
You also didn't tell Mr. Horace that when he got in the car, you told everybody in the car about the fact that Mark was a pornographer and that he had done creepy things and that he had tried to do creepy things with you while you were in high school, right?
I never said that.
And you also didn't tell anybody in the car. Well, let me back up. You told Mr. Horace that when Mark told you that the photo shoot was called off, there was a demand to look into Mark's backpack to see if he really was a photographer, right?
No, sir.
And you told Mr. Horace that when you looked into the backpack and there was an examination of this camera, that you found child pornography in it, right?
Objection,
No, sir.
objection, relevance.
Sustained.
First, please.
Yes, you may.
Uh-oh. Uh-oh. I told you. This day became oh so much worse. All of a sudden. Oh so much worse. Because it seems like not only this case became all of a sudden much more. It seems like this witness, Miss Reyes, had some kind of interaction with the victim already in high school. And then they went through his backpack, and then they went through his either phone or camera and found CP. Now that was objected to by the prosecution. Because this is from a motion in limine pre-trial. They were not allowed to talk about the victim's history with CP. So things in this trial are about to take a turn for the absolute worse for everybody involved. The victim, Ms. Reyes, and the defense.
Approach.
And now they are approaching. Because let's just say Judge Boyd doesn't take kindly into violating a motion in limine that they had pre-trial. Skillet Pan says, can I put day in? Yeah, oh, day, yeah, sorry. I had it in the thumbnail, but I don't think I had it in the... Day 6. There. Let's see it on. Day 5. Oh, I'm changing.
All right, defense. The state filed a motion in limine. Defense, you were aware of the state's motion in limine. And I informed both parties, either side, if you have a motion in limine, before you enter into any territory that's the subject of the motion in limine, that you approach. And the reason why I do that is because, as both parties know, I do not know what the evidence is in your case. I don't know any facts of the case. I'm hearing this case as the jury is hearing it. And in the state's motion in limine, on page 2, it states, the state requests that the court grant this motion in limine and instruct the defense counsel to approach the bench and present the proposed evidence outside the presence of the jury before voir dire, opening statement, questioning, or in any matter bringing any witness or evidence of any of the following matters. And the number one thing says, any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. So, defense, it appears to the court that you've violated the motion in limine, unless you're going to try to tell the court that possession of child pornography is not a bad act.
Just to make sure here, the jury has been sent out for this. The jury's already been sent out. Okay. Yeah, I updated the title. Thank you for reminding me. Yeah, I can understand that it might be confusing if I don't have the day. No, Konsaki. During the sidebar, the jury was sent out, I believe.
Your Honor, what I'm trying to elicit from the witness.
No. The question is whether or not you were aware of the motion in limine, which you were, and whether or not you violated it in regards to violation of condition number 1. What you're trying to do with the witness, and excuse me, I'm going to have the witness step down. And counsel, you'll take your client to the back. You're still under oath and the rule has been invoked. And what I can tell you, unless you have some photos of child pornography that you're saying that the complainant had, then you're just throwing questions out and you're violating the motion in limine. It clearly states that you all are supposed to approach. Now, unless you all think that child pornography is not a bad act, then I don't know why that's a crime. Because if you're saying it's not a bad act, you asked this witness a question and it involved child pornography. Did I hear that incorrectly?
You heard that correctly, Your Honor. And I'd like to also make aware to the court yesterday when we approached about my motion in limine, the court specifically regurgitated condition number 1 to defense in regards to the nude photos.
Your Honor, I understand that the court is of the opinion we violated the motion.
No, not of the opinion. You violated the motion in limine. The motion in limine says that you are to approach before questioning or in any matter bringing any witness or evidence of any of the following matters. Any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar. And you're asking this witness about whether or not he had child pornography or something in his camera. The court considers that a bad act.
Your Honor, to be clear, the questioning of the witness is intended to establish whether or not she previously made these statements. They're not being offered under Rule 613 for their truth. They're being offered for what she said to another individual.
You are still, what you're questioning her about is a bad act that she said that was the bad act of the complainant, and that's a motion in limine. And you all should approach before you do that. You violated the motion. The court is finding that you violated the motion in limine. And the only question now is how is that corrected? Because nobody approached the court to say, I'm going to start asking questions that is related to number one, to the state's motion in limine.
I understand the court's ruling. I've given my explanation for it. As far as the remedy is concerned, the court will do as it sees fit. I
I
understand.
know I am, but you're still, it appears to court, acting as though you haven't violated number one, and you have. You violated that motion in limine.
Your Honor,
And I can tell you, yes, counsel.
I think we're slightly, we understand the court's ruling. However, I do want the record to reflect, at least, that what we're asking is what the witness's previous statement. We are not accusing anybody of anything, and we're certainly not trying to accuse Mark, and we will be happy to explain to the jury.
It's still a violation of the motion in limine. Hypothetically, if
If
somebody were to ask for it, any defendant, not just your defendant, if somebody were to ask a witness on the stand, hey, by the way, and didn't you tell somebody else that the defendant had possession of child pornography, the defense would be objecting because it's
Let's just say I think I kissed the monetization of this stream goodbye.
a violation of the motion in limine. It's a violation of the motion in limine, in fact, and in spirit.
Well, it is intended because this witness gave a number of prior statements. One to a police officer during an interrogation, which was video recorded. Another under oath before another judge in a different court.
But here's the thing: it doesn't matter to the court. What matters to the court is that it's a bad act, and all you all had to do was approach the court. I would have heard it, what you are seeking to get from this witness, and I would have made a ruling on it. But instead, you have people who are violating rules, and I'm finding you violated the motion in limine rule. It's not supposed to be brought up until it's brought up to the court outside the presence of the jury. Now, what you have done is by bringing this up, I don't know if the jury's going to believe he was in possession of child pornography or not. I don't know if he was in possession of child pornography or not, because nothing has been presented to the court. And all you all had to do was approach the court and said, Your Honor, I believe we're going to go into number one of the state's motion in limine. And you know what I would have done? I would have had the jury step out and I would have said, okay, what's the issue here? And you would have told me that, and I would have made a ruling.
I believe this came up yesterday.
No,
Yes.
not the possession of child pornography.
Possession of photographs on the camera of,
Of nudes.
right.
That's it, of nudes. And when we were here at the bench, I even told the state, okay, he has nude photos, allegedly. I said, how is that a bad act? Having a nude photo is not necessarily a bad act.
I see. what
And
you're saying.
both parties said, yes. Mr. Hunter, yes, Judge, you're right. It's not a bad act. And then we go a step further today, and now it's possession of child pornography. And I'm not going to allow you all to ask that question, and I'm going to instruct the jury to disregard.
We understand, Your Honor.
We understand. And there are some additional matters that she spoke of that have nothing to do with nudity or pornography. And
And what would that be?
Your Honor, I don't believe that any other bad acts or potential bad acts of Mark Anthony Saldivar will be discussed other than those things which were discussed in opening statement related to the.
I'll determine whether it comes in or not. And you know why I'm going to determine whether it comes in or not? Because there was a state's motion in limine that says any crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, you'd approach beforehand. And I need to make a ruling on whether or not it's relevant and whether or not it should be admissible. That's me. That's my job.
I understand your.
So what other acts or what other bad acts that you feel, crimes, wrongs, or bad acts of the victim, Mark Anthony Saldivar, that you feel this witness is going to be questioned?
I can tell the court that it's going to be, and I don't know if it'll be disputed or not, that he damaged the vehicle. I guess that could be considered a bad act. I want to.
Well, with regards to the damage of the vehicle, allegedly, it said that he put his foot through the glass of the vehicle. That's a part of this whole alleged offense and the offense date. So, counsel, you all know that if there's evidence that's going to come in that he damaged the windshield, that's already in through other people.
Right. And the issue of what she said back to that, to our client, she says that she didn't say anything, that she looked straight ahead, didn't look to the side.
All right, so
behind.
here,
May I just finish?
we're getting off track. Where were the bad acts?
Well, I'm going to suggest that she has told people. And I believe if she says that's correct, that I never said anything other than that, to Mr. McIntyre, part of the race just of the offense, if she said something other than what she told the police officer, I believe that's a prior inconsistent statement, and we're entitled to ask her about it. And by the way,
I'm
it
not
has nothing
challenging-
to do with
I'm not
pornography, sex, anything else.
Counsel, I'm not challenging anyone on inconsistent statements.
Okay.
I'm not challenging anybody on that. The court knows the rules of evidence. What I am saying is there's a motion in limine. And I think it's safe to say for the people who have been practicing even a year that you know you're not supposed to violate motions in limine. And number two, if there's an alleged offense and videos have been shown in exhibits that it's alleged to be, or maybe the jury feels it's already been established that the person who kicked in a window or damaged the window of a vehicle is the complainant because witnesses have said it's the complainant who did that. So you all know questioning the witness about that, that's really not about the motion in limine. The motion in limine is about your co-counsel violating it.
My able co-counsel, I can tell you if I can get 5 seconds, I believe he will go into next the matter of what was said that precipitated the fight.
All right,
And
let me just-
I don't think it's about anything, and I think we're entitled to ask the witness.
Let me just tell you,
Yeah.
you violated the motion in limine.
We got that.
You will not ask this witness any questions about child pornography on a camera unless you have
We agree.
proof
We're
that
not-
there's child pornography on a camera.
Well, by the way, we do have proof of that, and
Mhm.
it was a legitimate question. However, the court's ruled on it. That's not what I'm discussing. I'm talking about what we're gonna do next. And while I can't look into his mind, I presume, since the court has ruled on it, we can make a bill later, but we're not gonna do anything in front of the jury. However, I do believe conversation, what she tells the police officer, what she tells the judge, if there's somebody that says you said something else, I believe that's fair game, that's impeachment. And all I don't want to do is, we shouldn't have to have a hearing like this before we ask every question.
No,
And if it doesn't involve child pornography or some extraneous offense, I think we're
no,
entitled.
you all have to have a hearing because it's a part of their motion in limine.
Not
you
not
can't
if it's
just-
not an offense
Here's,
or
yes,
misconduct.
and the last time I checked, possession of child
I
pornography
would agree.
is an
And-
offense.
And we're gonna be chastised and the court's gonna do something.
Oh, no, my chastisement is just stating the law. There's a motion in limine in place and the defense has violated. And I am not going to allow you to ask questions about child pornography.
We're not gonna do that based
Uh-huh.
on the court's ruling. However, we should be able
Your Honor,
to.
just in anticipation, the only other aspects of this questioning that I believe will venture into territory that the state might object to would be questioning about whether or not she had a hand in getting the gun into Mr. McIntyre's hands, if that is in fact what happened. And secondly, whether or not she is the source of the marijuana, which I'm not clear on.
All right, so here's the thing. And let me just tell you, this is what I'm going to say this.
She was asked that.
This is what I'm going to say, and I want you all to listen to me clearly. Both sides have been practicing law for more than 2 seconds. Everyone here knows that if you're asking questions and those questions are related to what's already been brought in evidence, the marijuana, it's already in there. It's already in the evidence. Who had it, what they did with it. Yeah, you can ask questions about that.
And guns.
The gun, it's already there. But I don't want any deflections where people are pretending as though they don't know that they violated the motion in limine. So I'm bringing the jury back in and I'm telling them to disregard the last question. I'm telling them to disregard any testimony or questions about child pornography. Does everyone understand?
Yes.
And the defense, you violated the motion in limine.
Whew, that was a handful. Yeah, I told you, this case is blowing up. Told you. I had no idea about, I had to go back. Was there a motion in limine? Yes, there was. So, in my opinion, the prosecution knows that the victim in this case apparently has been going around high schools looking for minors to photograph as I'm a well-renowned photographer. Come here, you look so beautiful. Let me take your picture with minor girls. does this have anything? I mean, even with that fact, could it still be murder? Yeah, it can. Is it? Yeah, it's just so very. This is what may or may not cause your jury nullification, folks. Because if the defense, through later in this trial, through testimony of their witnesses or evidence of what was in his phone or in his camera, and they can show these are minors. Gwendolyn says, well, so what is the defense's point? Our client is innocent because the victim did bad things. No, I think their point is that the witness has a huge interest in pointing finger at their client, because it seems like she planned it, she brought the gun, allegedly, put the gun, made the situation so much worse, put the gun in somebody's hand, and then that person fired. Does that take anything from the defendant? I don't know. I mean, according to Texas law, everybody in that car who participated in this crime are equally guilty, if that is what the prosecution can prove. Yeah. GD says, although that would explain why the victim was trying so hard to get back in the car to retrieve his camera and phone. Yeah, because if they kept that and turned that over to the cops, yeah. And as interesting says, the line of questioning is to impeach her on prior statement. And all of those up until that particular question, completely valid. But then they said the CP word, and all hell broke loose. So I do believe that it was a mistake. I don't think it was a mistake as in they didn't mean to. They definitely meant to. But the mistake is doing it without talking to the judge first and showing evidence to the judge. Hey, he had pictures of minors in his camera, and she told this to her now ex-boyfriend. All right, let's continue. I told you this was going to be interesting. Going into my...
Oh, if you could have your witness take the stand, please.
Yeah, prosecution. Maybe, just maybe.
Your Honor, may the record reflect that the witness was not in the courtroom while those discussions were happening?
Yes. Just 1 second. They're going to bring the witness back in.
Yeah, I don't think the jury is going to disregard this as well. Pop says, what if Tay-K didn't know what was going on and the guy smashed the window and it was self-defense? That is, if the defense successfully argues this, then yeah. But we have to wait and see. It's not a complete it's not a complete self-defense, but they did bring up the self-defense aspect in opening statement. Pop says, I wondered earlier, and it seems like the defense has one of the witnesses' ex-boyfriend on their witness list. Yep. Hi, Veg. Yeah. For you who don't know, today was Jack Gotti about the things that took place in prison, that he's been in jail, even though he was acquitted in the YSL trial. And Judge Whitaker ruled on those alleged offenses and sentenced him to probation for 10 years. Yeah, it's, yeah, 10 years probation. Yeah, I think it's bullshit. I really do. But I will bring that up in a separate video. My opinions on that. Hey, Mr. Jingles is here. Hello, Mr. Jingles.
And gentlemen, the last question that mentioned the words child pornography, you are to totally disregard that question. Does everyone understand? Is everyone able to do that? You are not to consider it for anything. You are to totally disregard the question. And I don't believe an answer to the question was made, but if an answer to the question was made, you are to totally disregard that answer as well. Does everyone understand? Is everyone able to do that? All right, defense, you may continue.
Thank you, Your Honor. Ms. Reyes, you said that you didn't see anything other than the condoms that were shown to you, correct? In terms of the contents of his backpack?
Correct.
But you told the detective that there was a roll of condoms, lube, and a new outfit in the backpack, correct?
That's what Taymor said.
Okay, and you believed that, right?
No, I didn't believe anything.
You didn't tell the detective you didn't believe anything.
He asked me what was in the bag, and I said what was said to me.
So when you explained it, you were explaining it in terms of what someone else told you, not in terms of what you believed to be in the bag?
Correct.
I'm gonna call your attention to this segment of your statement.
And he was like, give me all your shit, this and that, and then so the guy doesn't want to give him his stuff. And I was just like, what are you doing? And then he was just like, just shut up. And he was like, give me your stuff. And then they started pulling his backpack away from him. And then that's when they opened it and saw all that stuff.
So what was in the bag? You said-
There was a roll of condoms, a lube, a bottle of lube, and a brand new outfit.
And Judge, sorry, just for purposes of the record, what portion was that? I don't know what,
I'm so sorry.
yeah, the VLC player numbers.
I believe that's at 1641.
1641. Thank you.
So when Mark gets in the car, he says, in your words, he wanted to reschedule the photo shoot, right?
Correct.
But you proceeded to drive away from his house anyway with
He
him in the
asked
car.
me for a ride to North Star.
Okay, so you were driving him to North Star Mall, which was where you were going anyway, right?
Correct.
And that obviously caused confusion in the car, correct?
Objection, speculation.
Sustained.
When he told everyone in the car that he was going to have to reschedule the photo shoot, there was a question in the car as to whether or not he was even a photographer, right?
No,
Objection,
sir.
hearsay.
That would be overruled.
And that was when the demand was made to see the inside of the backpack, correct?
No, sir.
And it's then that the men found condoms and lube in the backpack, right?
I never saw it.
And again, Mr. McIntyre was your boyfriend at the time, right?
He said I was his girlfriend.
Okay. You weren't dating Mr. McIntyre at all? That you don't recall your testimony from yesterday?
Yes, I recall it, but he would call me his girlfriend.
Okay. You were dating him, right?
So he says.
Okay. You dispute that now?
I always said I was never wanting to date him.
Okay. You recall your testimony yesterday,
Yes,
and you recall saying that you were his girlfriend yesterday.
yes.
Okay. So when they find the lube and the condoms in the backpack, that's when a physical altercation breaks out, right?
I never saw it, but yes.
And that's when you handed Taymor a gun, right?
No,
That's what you told Mr. Horace, correct?
no.
And eventually, as the struggle continued, that was when eventually Mark was ejected from the car. He was thrown out of the car, right?
I asked them to let him go after they were beating him.
And when we talk about they, Jalen Bell and Jeremiah Rodriguez were in the backseat of the car with Mark, right?
All right, it seems like the defense will. I'm a bit confused here because now through their questioning, they are admitting that Tay-K had the gun.
Correct.
They were the ones who had the easiest access to hit Mark, right?
So it's Taymor.
Okay, so you described that Mark would have been sitting directly behind Taymor, correct?
Yes,
Okay. And so when Mark gets out of the car, he jumps on the hood of the car, right?
not immediately.
Right, he tries the doors to get back in first, correct?
Correct,
And then when that doesn't work, he jumps on the hood of the car.
correct.
And while he's on the hood of the car, he begins to stomp the windshield, right?
Once we were in the Chick-fil-A parking lot, when Taymor told me to drive the car back and forth.
Objection non-responsive.
Overrule. You can
Finish the
answer.
question. Answer.
That's when he smashed the windshield.
Okay. And he was kicking the windshield, right?
He kicked it once.
And you said he was kicking the windshield at you, correct?
He kicked it once.
I'm asking you, have you said previously that he kicked it at you?
I don't know who he was kicking that.
Okay.
Yeah, that's Miss Miss Reyes. When you do prior statements, you can. Because this witness had perfect recollection during direct examination of the prosecution, and all of a sudden her memory is very, very loose. And the defense on their witnesses has her ex-boyfriend, who she apparently told everything to. Yeah, she's not so happy at the moment.
Ma'am, I'm going to call your attention to roughly minute 7:05 of the interview.
And thank you to thank you to Brain Socks over at Rumble for your $2 Rumble rant. Saying thanks, Nick. A little support. Thank you so much. That is so nice of you.
Afterwards, I was the guy that I had, well, Taymor, he messaged me through Instagram because he wanted us to get a photo shoot. So that's what we're messaging about. Then Taymor would take my phone and he was talking to him. Like, Taymor had my phone the whole entire time. I barely got to talk to my mom, anyway, so one day he was just like, okay, we're gonna go pick him up so we can have our photo shoot. I said, okay. So we went and picked him up. He asked me if I could just give him a ride to North Star. And I was like, okay, that's fine. And so we were going. And out of nowhere, we were at a stoplight and Taymor takes out a gun and tells me to go everything. I didn't know this was gonna happen. I swear on everything I didn't know this would happen. And they all just started fighting. And I'm at the light and I'm like, I don't know what to do. I don't know what to do. And I was like, please just let him out, just let him out. And they were pushing him out. And I think Taymor grabbed his backpack and opened it and took out everything inside of it. And what we found was a roll of condoms, a bottle of lube, and a whole brand new outfit. So he was like, just get him out of the car, get him out of the car. So they were pushing him out of the car and he was like, no, I'm not going anywhere. And he was trying to get back in the car and they were trying to push him back out. And the light was still red the whole entire time. And I was just there like, I don't know what to do, I don't know what to do. And Taymor was just like, shut up, shut up, shut up. And like, I was just like, okay. And I was just at the wheel. And then we were pushing out, I guess it was finally to green. I was like, okay, this is my chance to get away from this dude. So, and then he jumps on my hood. And I was like, oh my God, what do I do? And I still didn't know what to do. Taymor was like, keep driving. And he pointed a gun at me. He was like, keep driving, keep driving. And I was like, no. I was like, and I was just on the highway, so I'm getting away. And he was like, no. He was like, pull over somewhere. So I pulled over and he wanted to get Chick-fil-A. And the guy was kept stopping on my hood and everything. I was trying to back up to get off my car. And I didn't know what to do. Like, I really was just going back and forth because I didn't know what to do. And then Brad said something and he kicked it through. He started kicking me through the windshield, and that's what Taymor did that.
What did you
He shot him.
So you told the detective that he was kicking at you through the windshield, right?
Yeah.
You also told the detective that you said we found condoms and lube in the backpack, right?
I said that, but I never saw it myself. And I made that clear afterwards.
And in the course of that, roughly slightly after 8 minutes and 25 seconds into it, you say the phrase, and he pointed the gun at you. And I just want to get a sense of this. During the exchange, when Mark is on the hood of the car stomping, you told everybody in the car that you thought he had a gun, right?
No,
That's what you told Mr. Horace, though, right?
no, I didn't.
And that you were yelling, he's got a gun.
No, I did not.
That's when Taymor shot him, right?
No,
You originally indicated that you didn't know whether anyone had a gun in the car when you got in the car that day, right? You remember telling the detective that?
I said that Taymor and Jalen always carried a gun.
Okay, so you don't remember telling the detective that you didn't know anyone had a gun when you got in?
No.
Seems like this witness have an
then
issue
later in the
with
interview,
the truth.
You're asked about what gun Jalen Bell was carrying, and you specifically told the detective he was carrying a 9mm, right?
Yes, that's what he always carried.
Oh. Oh. So who actually was in the front seat and who actually did everything? And yeah, this is how do I say this without saying too much? She's a lying hoe. Okay. I think I that's the most diplomatic I can be here.
After the shooting, as you're driving away, Jalen Bell had the backpack, right?
I don't know who had the backpack.
And you know that it was Jalen Bell who threw Mark's cell phone out of the car, correct?
So he said,
Okay, you didn't believe that?
I never saw it.
Did you tell the detective that Jalen threw the phone out of the window?
Correct.
So first you say you don't remember, but then you told the cops that he'd... Oh, this is not good.
And you know that it was Jalen who went through the wallet. I believe you testified to that fact yesterday, correct?
Correct.
Now, I want to get something clear. You testified that Mark got into the car with a backpack and a camera. You recall saying that?
Correct.
Was the camera in the backpack or was it separate from the backpack?
I never saw it.
You never saw a camera,
I knew he had a camera.
But-
He was a photographer.
but you say you didn't see it.
I didn't see if it was outside the bag or in the bag.
Okay. What's in Ector County? Odessa?
Yes.
What's there?
Objection relevance.
What's the relevancy?
He was apprehended in Ector County.
All right, objection sustained.
Where did you go? Where were you when you were arrested for this?
Odessa.
Okay. Why did you go to Odessa?
Objection relevance.
Overruled.
Kayla's friends took me over there.
Okay. Which friends?
Deja and Keon.
Okay. They gave you a ride?
Yes.
Did you have any family there?
No.
You have any connections there?
No.
After this incident, and after Taymor and Jalen left Jeremiah's house, you never saw Taymor again, right?
No, only the FaceTime.
Okay. But you often told others that you were unable to get a hold of Taymor on FaceTime, right?
Not true.
Okay. You weren't upset that Taymor wasn't responding to you or answering your phone calls?
Not at all.
You remember that you were at one point concerned that you might be pregnant and you were trying to reach him and you couldn't get a hold of him?
No, they're manipulating me to think that I was.
Okay. You're referring to who when you say they?
Kayla is that.
Okay. You don't remember the night that Desiree found out she was pregnant?
Objection relevance.
It goes
Sustained.
directly to what she's testifying to.
Sustained.
Do you not remember telling Desiree and Kayla that you thought you were pregnant?
No.
You don't remember Kayla and Desiree encouraging you to take a pregnancy test so you know one way or the other?
Kayla made me take a pregnancy test.
Okay, and you weren't pregnant, right?
No.
When you left San Antonio yourself, you went by way of the Greyhound bus, right?
Correct.
And your father took you?
Correct.
And you didn't tell your father that you didn't want to go to Dallas, right?
No.
And when you went up to Dallas, you stayed with Kayla and Desiree, right?
Correct.
And you called Kayla and Desiree and asked if you could stay there, correct?
I only stayed at Desiree's one night.
Okay, you stayed at Desiree's parents' house, right?
Correct.
They had a barbecue, right?
No, we didn't.
They didn't offer you barbecue from a previous occasion?
No, I didn't eat.
Um, while you were in Dallas, you were working as a stripper there too, right?
They made me, yes.
And in order to dance in the Dallas strip club scene, you have to register your fingerprints and show your driver's license to an authority figure, to the county, right?
No, sir.
Okay, you never went to the county to get your fingerprints taken?
Yes, but I didn't have to do that at the strip club.
Right, but you did it for your work at the strip club, right?
No, sir.
Okay, why did you go get your fingerprints taken in Dallas County?
Because they didn't ask for that.
I thought you just said that you did get your fingerprints taken.
For my ID.
Okay, well, you gave them your ID, right?
Correct.
And they photocopied it?
Correct.
Okay. And that was in order to get an ID for the strip clubs, right?
Correct.
To verify that you were old enough to dance, right?
Correct.
Okay.
Holy crap.
That would have been obviously before you say that your bag and all of your identifiers were stolen, correct?
Correct.
Apparently they fingerprint strippers in Texas. Hey, tater salad. This case is a hot mess. Let's just say that. Let's just say that. Jesus Christ.
When you were interviewed by the detective, you indicated to the detective that there might have been some problem in your family with you dating an African-American man. Do you remember that?
Objection, relevant, Your Honor.
Sustained.
It goes to bias here.
Sustained.
Please note my exception.
Motion to disregard, Your Honor, or instruct the jury to disregard.
All right, you didn't disregard the last words from counsel. Does everyone understand? Thank you.
You asked the detective if he could put money on your book so you could call your mother. Do you remember that?
He asked me if there was anything he wanted me to tell my mother, or he wanted him to tell my mother. And he asked me, should she put money on her books? I said, yeah, that's fine.
Okay, so he was going to facilitate her putting money. That's what that was about?
Yeah, he said it.
Okay. Do you remember the day that you pled guilty to tampering with evidence in front of Judge Contreras?
Correct.
And you were asked questions by the prosecution related to this offense because they knew that it would probably be some time before you would have to testify in the case, right?
Correct.
And they wanted to, I believe, get a baseline of what your testimony would be at trial. You remember that?
Okay.
And you were asked about the intent to rob, whether or not there was an intent to rob associated with this case. Do you remember that?
Correct.
And you told the judge and the prosecutor, I guess so?
After seeing it, yes.
Okay, but did in your response to the question about whether there was an intent to rob, you said, I guess so, right?
Because it happened. I said, I guess so.
I'm just asking you, is that what you said in response to the question about whether there was an intent to rob? I guess so.
Correct. That was what I said.
And you don't remember how many gunshots were fired, right?
I think this Miss I think Miss Reyes, her emotions is not as
at that
much
hearing-
feelings about the victim. It is, oh crap, I lied and I am being so caught in lying that it might, now this is up to the prosecution and the judge, but it might affect her probation. Uh-oh.
Where you were testifying in front of Judge Contreras, you indicated that you barely knew Jeremiah, right?
When he was in school.
But you did attend school with him, right?
Correct.
So you had known him for a long time.
I knew of him.
Okay, but you had interacted with him before.
Not like that.
Okay, I mean, when you say not like that, what you're saying is you haven't previously been driving around town with guns and drugs in a car, right?
No.
But you've seen him in school, you've talked to him on multiple occasions, he's been to parties that you've attended as well.
I only saw him and hung out with him the time that we were at the gathering and after that.
Well, you knew that Jeremiah sold marijuana, right?
Yes.
You knew that Jeremiah carried a weapon, right?
Yes.
You knew that Jeremiah was a photographer himself and had his own camera, right?
Yes.
Yeah,
You stayed at his house. I believe you said for a couple of weeks, right?
It felt like a couple of weeks.
Well, how long was it in actual fact?
I couldn't know the time frame because we were always moving places.
Okay, so you just can't commit to how long you were there.
No, but it felt like a long time.
But then it was more than one night for sure.
Yes,
Okay, when you say a couple of weeks, is that an estimate?
yes.
but she didn't really know him. Now, Jeremiah and Mr. McIntyre are two different people. Remember that. Jeremiah is another person who was in the car and she now all of a sudden claims she barely knew him. Yeah, but how did he end up in your car on that day if you barely knew him?
Pass away.
State.
Oh, redirect.
If I can have a moment to get the screen set.
Yeah. Well, they got everything they needed. I mean, you can't really say that her credibility is in the shitter, figuratively speaking. Yeah, oh. Yeah, so we found out quite a few things here during cross-examination. She barely knew Jeremiah, but she had dated him and lived with him for at least more than one night. She didn't know the victim, but she interacted with him during high school and afterwards and saw him at parties. And she didn't date Mr. McIntyre, but she was his girlfriend. And I mean, she really... If you're going to lie, like I believe Miss Reyes do, you kind of have to... This is why lying is so hard. Because you have to remember all of them, especially if it is 8 years ago and different hearings and different things, and then all of a sudden you start dating again and you tell your now ex-boyfriend about what really happened or might have happened in the car. All of that, all of those lies, yeah. Yeah, and as Pop says, she keeps saying she was forced to do everything, but Tay-K was a minor and she was an adult. Yeah. At the time, Mr. McIntyre was her height, and soaking wet weighed maybe 90 pounds. I mean, he was a tiny dude. But she believed him when he said that he was 18. Yeah, sure. Can you spell statutory rape? Anyone? She was legally an adult and he was legally a minor. Yeah, he weighed as much as my head.
Ms. Reyes, I want to show you what has been entered into evidence as State's Exhibit number 126. This item that I'm pointing at, do you recognize what it is and who it belonged to?
Slides.
And who did those slides belong to?
Taymor.
Okay. Now, I want to talk to you about your interview with Detective Juarez back on September 5th of 2017. During that interview, did you inform Detective Juarez that you had told Mark Saldivar that you would be with at least 2 friends?
Yes.
Okay, and just going back to when you told Mark Saldivar that you would be with 2 friends, Why did you say that?
Because I wanted to make them aware of what was going to do.
Okay. And when you showed up, you were with 3 friends. How did that third person get into the picture?
Then I decided to want to go.
Okay. Can you please describe to the jury the relationship between the defendant and Jalen Bell? Were they friends with each other?
Best friends?
Okay. Did you observe them staying together?
Yes,
And would you observe them together frequently?
all the time.
And, okay. Now, during your interview with Detective Juarez, did you inform Detective Juarez that the defendant was specifically looking for a photographer for a photo shoot?
Correct.
And during your interview with Detective Juarez, did you inform Detective Juarez that prior to what happened at the stoplight on McCullough, you had no knowledge of the defendant's intentions to rob Mark Saldivar?
Yes, ma'am.
Okay.
Yeah,
In your statement to
sure.
Detective Juarez,
In
did you
my
tell Detective Juarez that the defendant only told you that it was going to be a photo shoot?
Yes, ma'am.
Okay. In your statement to Detective Juarez, did you tell Detective Juarez that the defendant told Mark, give me all your shit?
Yes, ma'am.
In that interview, did you tell Detective Juarez that Mark didn't want to give up his belongings?
Yes.
In that interview, did you tell Detective Juarez that they took Mark's backpack away from him?
Yes.
And when you say they, who do you mean?
Taymor.
Does that include anybody else?
Taymor.
Okay. In your interview with Detective Juarez, you stated that they opened Mark Saldivar's backpack. Is that correct?
Correct.
When you say they, who are you referring to?
Taymor.
Does that include anyone else?
Taymor.
And in your interview with Detective Juarez, did you tell Detective Juarez that they beat Mark Saldivar?
Yes.
And when you say they, who do you mean?
Taymor.
Okay. In your interview with Detective Juarez, did you tell Detective Juarez that they threw Mark Saldivar out of the motor vehicle?
Yes.
And when you say they, who are you referring to there?
Taymor.
Okay. Now, in your interview with Detective Juarez asked you if Mark Saldivar was in possession of any weapons. Is that correct?
Yes, ma'am.
What did you tell him when you had the interview with him?
No, he didn't know the boy don't have one.
Okay. And in your interview with Detective Juarez, you further stated that you didn't believe that the defendant was acting in self-defense. Isn't that
Objection,
correct?
Your Honor. Calls for ultimate opinion on a legal.
He's opened the door, Your Honor.
All right, that will be sustained as to entering the province of the jury.
And I'd ask the jury to disregard the question and the answer.
All right, ladies and gentlemen, you're to disregard that last question and the answer.
Motion for mistrial.
Denied.
Now, I want to go back to the album cover and your role in the album cover, okay? When we're talking about you being in lingerie, whose idea was that?
Taymor's.
And in your interview with Detective Juarez, isn't it true you told Detective Juarez that the defendant, Taymor McIntyre, is the one that made you agree to wear lingerie?
Yes.
Okay. Now, when you spoke to Detective Juarez, isn't it true that you told him that the defendant was the only person that you saw with a gun on that day?
Yes.
And isn't it true that in that interview with Detective Juarez, you also informed him that the defendant was wearing a white shirt during the offense?
Yes.
And during that interview, you further stated to Detective Juarez that you observed the defendant shoot the guy on the hood of your motor
Objection
vehicle.
to leading, Your Honor.
Sustained.
In your interview with Detective Juarez, what did you tell him about who shot the person that was on the hood of your motor vehicle?
I said Taymor did it.
Wait here. Going to play that in.
Person that was on the hood of your motor vehicle.
I said Taymor did it.
So
During your interview with
she
Detective Juarez,
told the detective that she did it. Uh-oh.
what did you tell him about Jeremiah Rodriguez and what he would sell?
And he sold marijuana.
And you further informed Detective Juarez that you knew that Jeremiah usually carried firearms, correct?
Yes.
Okay. During your interview with Detective Juarez, you also informed him that you, the
Oh, she
defendant,
said
and
Taymor
Jalen Bell
did it.
were staying at Jeremiah Rodriguez's
Thank
home
you.
for at least 1 week prior to the offense,
Objection
correct?
to leading, Your Honor.
Sustained.
Instruct the jury to disregard the question.
Ladies and gentlemen, disregard the question.
Motion for mistrial.
Denied.
When you spoke with Detective Juarez during your interview, who did you tell him? What did you tell Detective Juarez about where you were staying with the defendant, Taymor McIntyre, and Jalen Bell?
Jeremiah's.
Okay. And when you were answering Mr. Hunter's questions, you kind of further expounded that you couldn't pinpoint an exact time frame. Is that correct? But you're sure that you were there for some time, right? Okay.
This is a hard
Now,
one to
in your interview
recover
with
from,
Detective Juarez,
prosecution.
when you were asked,
Especially since you keep asking questions you know you're not allowed to. This happened with all the witnesses. All the witnesses, so far, the prosecution have asked questions they know they can't. And I know that Judge Boyd chastised the defense, but that was an especially egregious one. I have nothing against that. But at what point is this line of questioning, which the prosecution knows they can't ask, at what point does that become a tactic in the case?
who had the backpack when you were at the Mexican restaurant, do you recall who you told him had the backpack?
Yes.
Who was that?
Taylor.
And when Detective Juarez asked you about the camera that Mark Saldivar had, do you recall telling Detective Juarez what color that camera was?
Objection leading.
Overruled.
What color was the camera?
White.
And is that what you told Detective Juarez in your interview?
Yes.
All right. Now,
This is a very, very odd place to cry. Why all of a sudden, yeah, I thought she said she didn't see a camera. And why is she crying now? I don't buy this.
Mr. Hunter asked you a question about whether you saw the camera when Mark got into the vehicle. Do you recall that?
Yes.
Do you recall the exact moment that you saw the camera?
No.
Okay. After the offense, when you all were at the Mexican restaurant, had you seen the camera?
Asked and answered and leading, Your Honor.
Overruled.
You can answer the question.
Yes.
So you saw the camera at the Mexican restaurant?
No.
Okay. Did you see the camera when y'all were at Jeremiah's house?
Objection asked and answered, Your Honor.
Overruled.
You can answer.
Yes.
Okay. And when you were at Jeremiah's house, who had the camera at Jeremiah's house?
All the boys.
Did you see the switch on the witness? Oh, she was almost bursting out crying, and then boom, normal.
When you say all the boys, who is that?
Jalen, Jeremiah, Taymor.
Okay. Now, back to the Mexican restaurant. What did you observe Jalen Bell doing with Mark's wallet at the Mexican restaurant?
He was tossing all his stuff out.
And isn't that what you told Detective Juarez when you had your interview with him? Okay. In your interview with Detective Juarez, you informed Detective Juarez that you, the defendant, and Jalen Bell got a ride from Starbucks to go meet back at Jeremiah Rodriguez's home.
Objection leading, asked and answered.
The objection to leading will be sustained.
Okay. What did you tell Detective Juarez about where you went with the defendant and Jalen Bell after leaving the Mexican restaurant?
And so then
Objection hearsay.
Overruled.
I told him that we went to the Starbucks next door. And Taymor was on my phone. And then a woman came and picked us up.
Now, I want to turn to you about, or talk to you about the defense counsel's line of questioning regarding whether you thought the victim, Mark Anthony Saldivar, had intentions of having sex with you. We saw the video published to the jury, but is this something that was suggested to you by the defendant?
No.
Okay. After the defendant and Jalen Bell went through the bag, what did they say to Mark regarding the items that they saw in the bag?
Taymor said, what do you think that you were going to do? What do you think you were going to do?
Okay. And on the statement that was played for the jury, you said once you were told the contents of the bag, you were shocked and didn't know what to think. Isn't that correct?
Correct.
All right. But in talking to Detective Juarez, you were kind of guessing as to what Mark's intentions were. Is that fair to say?
Correct.
Okay. And you were kind of just stereotyping him in a stereotypical male way. Is that
I'm going
correct?
to object, Your Honor. This is leading, asked and answered, and it's functionally testifying from the prosecution.
With regards to leading, the objection will be sustained.
Motion to instruct the jury disregard the statement of the prosecutor.
All right, ladies and gentlemen, you're to disregard the last question from the state.
Motion from Ms. Trump.
Denied.
When you met with Detective Juarez and gave your interview, isn't it true that back on that day in September of 2017, you told him back then that the defendant was threatening to kill you? Okay. And the detective in your interview told you that he was listing you as a suspect in the capital murder, correct?
Objection hearsay.
That will be sustained.
Did the detective tell you anything about what could possibly happen to you if you spoke with him?
Yes,
Okay, and did that include being charged in the offense?
yes,
And you still decided to talk with him, correct?
yes.
And when you spoke with Detective Juarez, did you have any plea agreement in place?
No,
Did Detective Juarez promise you anything in exchange for your interview?
no,
At any point, well, you know what? Now I want to turn to the day that you entered your plea agreement. Do you recall that?
yes, ma'am.
All right. And you gave testimony on that day, is that correct?
Yes, ma'am.
All right. And so on the day that you gave testimony, isn't it true that you testified that you had met Taymor McIntyre at the gathering at Isaac Ibarra's house?
Correct.
Okay. And in that testimony, didn't you further state that you had been with Taymor McIntyre from the beginning of April?
Yes.
Okay. In the testimony that you provided on that day, isn't it true that you stated you and Mark followed each other on Instagram and Taymor wanted a photographer for his album cover?
Yes, ma'am.
In the testimony that you provided, isn't it true that you stated that Taymor told you what kind of plans he had for the album cover, and that included Taymor McIntyre wanting you in lingerie and wearing a mask with weed and guns? In the testimony that you provided, isn't it true that you stated that you, the defendant, and Jalen Bell were staying at Jeremiah's house?
Yes, ma'am.
And you stated the people that were staying at Jeremiah's house was Taymor, Jalen, Desiree, Jeremiah, and Jeremiah's family.
Yes, ma'am.
All right.
I can't wait for recross. And thank you to Polly Popcorn, gifted a membership. That is so nice of you. Thank you so much. And it went to Ronan. Now, Ronan, you have access to all my members-only content on YouTube. And there are quite a few hours, close to 200 hours of members-only content. You also have your own emojis in the chat. And you will gain access to my Discord. Thank you so much, Polly. Thank you so much. If anybody else is contemplating becoming a member, $3 a month, and you get all of that for just $3 a month. Thank you so much again.
Okay, and the testimony that you provided, you stated that you were the driver of that black Kia Forte, correct?
Yes, ma'am.
And in the testimony that you provided on that day, you further stated that when you picked up Mark Saldivar, he had a camera and a backpack, correct?
Yes, ma'am.
I'm going to object to ask and answer and cumulative. I also don't think it's a proper impeachment. They can't offer a prior consistent statement if we didn't attack that statement for fabrication.
Judge,
Objection is overruled.
thank you. Now, in the testimony that you provided on the day that you entered your plea agreement, isn't it true that you testified that Taymor McIntyre was sitting in the front passenger seat of your motor vehicle?
Yes,
And on that day, you further stated Jeremiah was sitting behind you, correct?
correct.
And you also stated on that day that Jalen Bell was in the middle seat, correct?
Yes,
And that the victim, Mark Saldivar, was sitting directly behind Taymor McIntyre, correct?
yes,
All right. On the day that you entered your plea agreement, you further testified that when you all were at the stoplight, Taymor brought out the gun and pointed it at Mark, correct?
correct.
You further stated on that day that when Mark didn't want to give up his bag, immediately Taymor started hitting him with the gun.
Correct.
On the day that you entered your plea agreement and provided testimony, isn't it true that you testified that Taymor used and pulled out the gun and stated to Mark, "Give me your backpack"?
Correct.
In the testimony that you provided on the day that you entered your plea agreement, isn't it true that you stated that you were telling Jalen, Taymor, and Jeremiah to just let Mark go?
Yes,
In your previous testimony, you testified that Jalen pushed Mark out of the car, correct?
correct.
All right. In your previous testimony, you testified that once Mark was pushed out of the car, he jumped on the hood of your car. Is that correct?
Correct.
And in your previous testimony, you testified that you pulled over into the Chick-fil-A.
Yes, ma'am.
In your previous testimony on the date that you
Yeah, now they're just going through the plea agreement in short form, more or less. But this also opens up for recross. A lot of things is being opened up for recross here.
entered your plea, you testified that Mark was on the hood of the car because his stuff was still inside the vehicle, correct?
Yes, ma'am.
And in your previous testimony, you did testify that Mark Saldivar kicked in the windshield, and that's when Taymor got out of the car and shot him, correct?
Correct.
When asked on that day how Taymor shot Mark Saldivar, you testified that the defendant, Taymor McIntyre, opened the door and leaned halfway out and halfway in and shot Mark Saldivar, correct?
I'm going to object to asked and answered. If we're going to go through everything in the transcript, we could just offer.
You can make your legal objection. The court will hear the legal objections and make a ruling. So what is your objection?
If I could have a running objection, since we're going through.
What is your objection?
That all of this is cumulative and asked and answered the previous, and much of it is not proper rehabilitation on impeachment by prior consistent statement.
All right, your objection.
If I may respond briefly, Your Honor.
Yes.
They have attacked this witness's credibility. They have alleged that she is testifying under an improper influence or motive. And so under Rule 801E1B, I am allowed to explore this line of questioning with her.
Objection is overruled.
And since they further stated that they have no objection to the transcript coming in at this time, the state would offer State's Exhibits 132, which is the transcript, and 133, which is her recorded video statement.
Any objection?
132, no objections, prior sworn testimony. Objections to 133, because the proper method of doing that is to.
Well, no, my question is, do you have any objection? And if you do, what's the legal objection?
That the entirety of the statement is not admissible. It contains a great deal of hearsay from another declarant not present to testify.
All right, and which exhibit is that, please? The one that the defense is objecting to?
That would be 133, Your Honor.
All right. Defense states that there's hearsay in 133. Any response?
If you'd like the detective's questions or redact, I can do that over a break and offer.
All right. With regards to State's Exhibit number 133, defense's objection will be sustained. And what is the other exhibit number, please?
132.
And defense, you have no objection to 132?
Okay.
All right. State's Exhibit number 132 is admitted without objection.
Ms. Reyes, at any point between the offense date until today, have you ever named anyone other than Taymor McIntyre as the shooter and murderer of Mark Saldivar? Pass the witness.
Defense?
Briefly, Your Honor.
Yes.
Did you ever tell anybody that he has a gun right before Taymor shot him?
Objection, that's been asked and answered.
Overruled.
She was overruled, sorry. Have you ever told anybody have you ever told anybody that you were yelling he has a gun right before Taymor shot him?
No,
You said that Taymor wanted this photo shoot for his album cover, right?
correct.
But you told Desiree in Dallas that it was for the promotion of your career as a stripper, right?
No,
And just to be clear, you've testified throughout this process that Jalen had the backpack and was going through it, and Jalen had the wallet, right?
correct. Taymor had the backpack as well.
And you told the detective that Jalen threw the phone at him.
That's what he said.
Okay, but that's not how you told it to the detective, right?
I said, that's what Jalen said.
Okay, let's go back.
Yeah, I'm not entirely sure which is which of item 132 and 133. But
Call your attention to minute 3619.
Sorry, what was that?
3619.
3619.
Oh, sorry.
Thank you. Thank you, interesting. For your $5 super chat, or is it a? Thank you. If you didn't write anything,
I'm sorry.
but
Did you say that
thank you.
that's what Jalen told you as they were thrown out of the car?
Yes,
Okay. You told the detective that you had no plan to rob Mr. Saldivar that day when you got in the car to go pick him up, right?
correct.
And your judgment of what Taymor and the other men in the car did is then based on their actions, not their words, right? To you.
Correct.
Nobody ever said, hey, Joanna, we're going to go rob this guy today, right?
No,
Okay. That wasn't something that you expected to happen when you got there, right?
no,
These men reacted to Mark when he got in the car and this thing escalated and then it happened, right?
it happened at the stoplight.
At the stoplight.
Yes.
Okay. So when you
All of this is so strange testimony from her because it is so inconsistent. Now, what would be consistent would be that she told the guys something about this, about the victim. And they agreed to do something, and then it escalated. That's the only story that makes sense out of all of this.
Told the detective you believed that this was a robbery. You're basing it off what you saw these men do at that stoplight.
Correct.
Yeah, I don't buy her story at all. Does it make any difference regarding the charges against Mr. McIntyre? I don't know. I really don't know.
And so, at the very beginning of our questioning yesterday, you and I were talking about the fact that Mark had contacted you previously on Instagram. You blocked him, and then you made contact with him again, right? And that you were discussing this photo shoot with Mark, right?
Correct.
And in that conversation, you weren't telling Mark that it was about the album cover, was it?
I don't remember texting him much. Taymor would text him as well.
Okay, but you definitely had conversations with him, right?
Yes.
And all of the conversations were on your phone, right?
Yes.
So let me ask you this. Did you give the police your phone?
No, because Caleb broke it.
Okay. So you didn't have a phone to provide the police?
No.
That would be evidence tampering, wouldn't it, prosecutor? But you only charged her for evidence tampering regarding the car, not the phone. That's interesting. That's really interesting. Why, Madam Prosecutor, did you drop the charges regarding evidence tampering regarding her phone? Why aren't the people... Because they knew this way back in 2018. Yeah, she's saying that Tay's sister broke her phone. Why? Why would she? Oh, I'm so sorry, Ron. It was I gave the wrong link. I'm so sorry. Hold on. There. Copy. Why doesn't it copy? Copy. There. Now it's there. So sorry, Ronan. Now you have the link for the Discord. But yeah, everything Joanna Reyes, she's blaming everybody else, and especially Tay and his sister. I don't buy it. I do not buy that for a second anymore, because of all the other lies. I believe this witness was smart enough to know that every piece of evidence would point everything in this altercation to her setting the victim up. So she knew to destroy evidence, but then she had to make up all the things that actually happened. And there is where her IQ isn't high enough, because she can't remember what lie she told what person, in my opinion. Again, does this mean that Tay-K will be acquitted? Well, we just have to wait and see.
Do you have the broken phone provided to the police?
No.
Okay. Did you give the police your account information to log into Instagram?
Yes.
Okay. Did you give the police account information to log into Snapchat?
Yes.
Okay. So you don't know what happened to those things?
No.
Okay. Were you given any Instagram messages or Snapchat messages to review in preparation of your testimony?
No.
Ask the witness.
No further questions.
Is this witness excused or subject to recall?
Used by the state, Your Honor.
Subject to recall.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial. Make sure that you're available in case someone, either the state or the defense wishes to recall you. All right, you may step down.
Oh, what a fustercluck this witness was. And I suspect highly, because if she is this not credible, remember, there are two more guys. There are two guys who were also in the car, who also got plea deals to testify against Tay-K, Mr. McIntyre. And if she is doing that bad, oh, I don't think the other two will make good witnesses as well.
All right, ladies and gentlemen, we're going to take a brief recess for you all, and I'm going to have you all to come back at 3:25. Remember my previous instructions, you're not allowed.
She is subject, she's out for now, but she is subject to recall by the defense. And depending on what her ex-boyfriend and other people are testifying to, they can possibly impeach her with things she told the jury in this court, in this trial. No, she already on. No, she is out on bond. And the moment this trial is over, she will be on a 10-year parole, of which she have been on parole for 7.5 years. So effectively, she will go out. Well, technically she's on probation, on bond, or whatever's. She's been outside at least, but after this trial is done, she has 1.5 years or something. Thank you, Tater Salad.
To investigate anything about this case. You're not allowed to start deliberating amongst yourself. Everything that you need to know about this case is to come from the courtroom. Does everyone understand? All right, everyone, please rise for the jurors.
I agree, Tater Salad. She is the manipulator here. Nothing happened in that car that she didn't instigate. All right, they are on a brief recess. Let's see if anything happens during... Nope. Oh, besides Judge Gold taking other cases. Yeah, this is something I really admire Judge Boyd about. The trial is having a recess. And while that recess is going, she is handling other cases. Let's skip ahead.
And does everyone else have their court reporter microphones?
I do, Your Honor.
Yes, Your Honor. Yes,
Okay, all
Are
right.
you able to hear me? Testing.
Sorry.
All right, let's bring the jurors in.
All right, for the jury?
Who is this guy? He looks like a cop.
Oh, the Officer Jose Bonal.
All right, could you raise your right hand? I'm sorry, just 1 second. Could I have parties approach just briefly?
This is, I don't. Do I count this as a sidebar when she asked the parties to approach? Yeah, maybe I should. Maybe I should. Which brings us to sidebar counter 31 on day 6. Judge Boyd, please put.
One, can you tell us where you're currently employed?
Yes, sir. I'm currently employed for the city of Dallas as a police officer.
And how long have you held that position?
Approximately 18.5 years.
And do you have to go through certain training to become an officer for the Dallas Police Department?
Yes, sir. I had to go through a 8-month police academy. After that, I had to do a 6-month field
Yeah,
training
we don't
officer
need
type
his
of
CV.
$55, and his buddy hasn't came back to pay me.
Night.
I did, sir. I had a fellow officer with me.
And what officer was that?
It's Officer McComas.
And were y'all, I guess, riding together or were y'all riding separately?
We were riding together. Yes, sir.
And did y'all make this scene?
We made it out to the scene. Yes.
And when you made it to the scene, what did you do?
So we did observed a white van, taxi type of style van parked within the apartment complex, and so we made contact with the driver to check on the status.
And we made contact with the driver. What did you do after that?
So it's like, hey buddy, are you okay? And basically the driver responded saying, yeah, this guy owes me $55, and his buddy hasn't came back to pay me.
And you sort of motioned with your hand, like a thumb motioning towards your back. Was that what the driver was motioning towards you?
Yes, sir, indeed. We didn't even know that the taxi cab had an occupant, a rear occupant. So he kind of hinted.
And did you ever make contact with this occupant?
We did.
And how did you make contact with this occupant?
So the sliding door on the driver's side, on my side, opened up. I believe the taxi cab driver pressed the button, but it automatically opened up. That's when I saw the subject sitting second row seat.
The second row seat in the van. And what did you notice about this occupant of this van?
So this occupant appeared to be impaired. I'm not sure if he was half asleep or impaired. He was clearly impaired because you could tell he wasn't completely insensitive.
And did you make actual contact with this individual?
Yes, sir, we did.
And did you speak with this individual?
We did.
And did you ask him about if he had the money to pay the taxi cab?
We did, yes, sir.
And did he notify you of whether he had the money or not?
He had no form of payment.
And at that point, did you try to identify the individual?
I did, just to ensure we knew who we were speaking with.
And did he give you a name?
He did.
And subsequently, did you ever find out if that was his true and correct name?
So I ran back to the car computer and I ran that information and didn't check out.
And please explain to the jury what do you mean by not check out?
So the name he provided, we run into the system and I received a no records found, which is usually reserved for someone with no ID or someone providing fictitious information.
And then did you make contact with the individual again?
So at that point, yes.
And what did you do at that point?
So at that point, I was looking at depth of service as a possible arrestable. So I wanted to make sure the scene was safe. So I told him to step out of the taxi cab to ensure that he was patted down for officer safety.
And will you explain to the jury how you pat somebody down for officer safety?
Do you need me to stand, sir, or just talk?
You can just explain it if you can.
Yes, yes. So we have to make sure we know where the hands are, just so, because the hands will kill you. So when I told him to step out, I told him to face the van, and I grabbed both of his hands behind him. So I grabbed on his thumbs, because that way you can control the subject better that way. And as I did that, I went to perform my pat down, which is of the outer clothing. And when I went across his waistband, that's when I felt a bulge and a metal object.
And through your training experience, did you believe that what that object was?
Yes.
What did you believe it was?
A handgun.
And at that point, what did you do?
So at that point, I quickly pushed him on his back and pressed him against the van. I said, "You better not move." And I looked at my cover officer and I said, "Cuff him quick," because I was concerned to make sure I reach for the weapon.
And were y'all able to handcuff this individual?
Yes, sir.
And did you retrieve what you believed to be a handgun in his waistband?
Yes, sir. It was a handgun.
And at that point, was he detained at that point?
Yes, sir. He was.
And this handgun that you retrieved, do you know what type of handgun it was?
The black 9mm Smith & Wesson.
And you know the serial number of that particular weapon?
I don't recall. It's been 8 years. So.
Okay, and that's what I was about to ask you. You have a pretty good memory if you memorized it. But let me mark. I'm going to show you what's marked city exhibit number 34. Can you just flip through that and tell me if you can identify it?
Yes.
Yeah, I agree with Tater here. I can't believe this has taken 8 years to get to trial. Now, they were kind of on the run for a while, but at the beginning of 2018, everybody was in custody. So since 2018, I mean, it's 7 years. And the trial is not until now. And in my opinion, That is solely on the prosecution and nobody else. There should never be a 7-year wait for your day in court. That's just plain stupid.
State Exhibit number 134, it's not entered evidence, but the fact is that a police report that you and Officer McComas made?
Yes, sir. This will be my report.
Your report, okay.
Yes.
And so, I think the previous question was, do you have the serial number of that particular, handgun?
I do.
And what would that serial number be?
So it's gonna be L like Lincoln, E like Edward, J like John, and then it's 9244.
9244? Okay. And at that time, was that weapon seized and then placed in property?
It was, yes, sir.
Mark State Exhibit number 135. I'm going to ask you if you can cut that a little bit, please. And what your paper is.
Your defense, if you need to move about the courtroom, you can move about the courtroom.
Thank you, Your Honor.
If you can open it up and you can please retrieve what's inside of it.
Yes.
You can open that up. You can open that bag. Please do what the contents of that bag was and tell me if that is the handgun that you seized that night and if you have a serial number on it.
Yes, sir.
And is that serial number LEJ9244?
It is.
Thank you.
It is.
And in this bag also is contents of looks like a magazine. Is that correct?
Correct, sir.
And is that the magazine, or if you're aware, that goes to this handgun?
It appears to be magazine. Yes,
Appears
sir.
to be the okay, thank you. Judge, at this time, the state would be offering State Exhibit number 135 and evidence presented to the defense for the objection.
No objection.
All right, State's Exhibit 135 is admitted.
And it's, I'm sorry, Your Honor, I don't know if I said it, but and its contents.
No objections to the contents side.
All right, State's Exhibit 135 and contents are admitted.
This is the handgun that you took off the individual that night, is that correct?
That's correct, sir.
Now, at any time, were you able to truly identify the individual that you had today?
Yes, sir.
And what was his true name?
Jalen Bell.
Kevin Bell. Now, that individual, can you tell the jury, well, what was this individual's height?
Well, he's a pretty tall guy. I'm only 5'6", so I remember he stood over me pretty good. For my report here. So back then, when we had detained the gentleman, he was 6'4" and approximately 240 pounds.
And I see you looking down. Are you referencing your police report to decipher that?
Yes, sir.
And again, I understand it's 7.5 years later, so I understand
Correct.
that. And subsequently, did you arrest this individual named Jalen Bell?
Yes, sir, I did.
And this was on May 7th, 2017.
Yes, sir.
And what did you arrest him for?
So we arrested him for the gun. He had a little bit of marijuana on his person. We arrested him for a warrant and also for providing fictitious information as a fugitive from justice.
Yeah, so he did not do himself any favors.
Thank you, officer. We'll pass the witness, Your Honor.
Defense?
This encounter occurred on May 7th, is that right?
Yes, sir.
Okay, and you said at 4 o'clock in the morning or so?
It's just before 5, sir.
Okay, gotcha. And you said that you placed the gun in evidence?
This is my partner, sir.
Okay. Are you familiar with the place where guns are stored in Dallas County for cases
Yes.
like this?
Yes, sir, I am.
Okay. Are they kept in a separate kind of an armory section for evidence, or is like sort of all the evidence all together?
No, they have a separate place for it, sir.
Okay. Can you describe that place for the jury?
Well, they do kind of refer to it as an armory, and they do have it more on the back side of the location, which is referred to as the beta property room.
Okay. Y'all don't do maintenance on guns that are kept there, do you?
That's I would not know how to answer that, sir. I don't know that part.
Okay. You do know generally that it's important to keep evidence in the state that it's found in, right?
I would think so, yes, sir.
Okay. I'll pass the witness.
No further questions. May this officer be released, Your Honor?
Is this
Yes,
witness
sir.
excused?
Yes.
right, the rule has been invoked. You're not allowed to discuss your testimony
Yes, ma'am.
during the pendency of this trial.
Yes, ma'am.
All right, make sure you leave the microphone behind.
So he was there to, yeah, he was being arrested.
And if you all
And
want
what
to
was on it,
make sure
on him when he was arrested?
The evidence is packaged back up.
Yeah, and to, well, remember, the victim was shot with a 9mm. Mr. McIntyre has not been found in possession of a 9mm. Another person in the car was known to carry a 9mm.
State called David Pendleton.
David Pendleton is the next witness. I have no idea who that is.
If you can raise your right hand, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, let's put the microphone on your lapel.
It looks like
And yes,
Looks
and
like
make sure that you keep your voice up so members of the
a
jury
cop.
can hear. If you'll state your name for the record and spell your last name, please.
Yes, Your Honor. My name is David Pendleton. That's Pendleton.
All right, state, you may proceed.
Thank you, Judge. Mr. Pendleton, can you please just tell the jury what your occupation is?
I'm a firearms examiner at the Bexar County Criminal Investigation Laboratory.
Oh, God. Toolmark guy! Folks, we are about to hear shit science.
Most people just call it the crime lab.
And can you just explain to them what that entails?
On a daily basis, I'm going to examine evidence submitted to the laboratory, usually from criminal cases. That would include things such as firearms, ammunition, and ammunition components, such as fired cartridge cases or fired bullets. And I would try and make a determination if those items were fired in certain firearms.
And how long have you been working at the Bexar County lab?
A little over 19 years.
And is this the Bexar County lab, is it an accredited laboratory?
Yes, sir.
And can you explain to the jury just what that means, what that means to be an accredited laboratory?
Yes, sir. We're accredited by the by ANAB. It stands for ANSI National Accreditation Board. And essentially what accreditation means is that you have standard operating procedures that are accepted within the scientific community, and you follow those procedures.
And I'm assuming that you have to go through certain training, education to get to this position. Can you explain to the jury and tell them some of the training and education, if you can?
Yes. As far as education, I have a bachelor's degree in criminal justice and a master's degree in justice policy, both from the University of Texas at San Antonio. I'm also a member of the Association of Firearm and Toolmark Examiners, and I'm certified in the area.
Yeah, if you've been around long enough, if you've been around my channel long enough, you know my opinions regarding toolmark analysis. It's a shit science. The short version is they claim it's a science. It is not. Science has blind testing. You have people who actively tries to disprove your findings in science. In toolmark analysis, if a person who says, "Oh, I found a match," and give it to somebody else who is a colleague, that person already know that you believe it's a match. That's not blind testing. Never been. This is not according to the scientific method. What it is basically a subjective opinion that scratches on a surface can be matched to a certain item. Microscopic scratches can be tied to a certain... In my opinion, and there are many people, including actual scientists who agrees with it, or I agree with them, to be honest, is that this should only be used to exclude, never to include, because it is it's unreliable. And as interesting says, it's confirmation bias between peers. That is an excellent explanation. Thank you. And there are so much. There are states and countries that has states in the United States or counties in the United States that has removed this kind of evidence altogether. It's back in history with lie detectors and bite marks. It's not reliable as evidence. Hopefully, in a near future, there will be a decision in a higher court that says, no, you cannot use tool mark analysis to include.
Firearms identification by the organization. Majority of our training is actually within the laboratory. It takes several years, actually. We also conduct outside annual training when we can attend. And I'm also yearly proficiency tested by an outside agency, as well as I'm required to maintain a license by the state of Texas.
Thank you. And have you testified as an expert before?
Yes, sir.
Can you tell the jury how many times?
Somewhere around 100.
And I guess you do continuing education, as in conferences or other type of continuing education to keep up with the times?
Yes, sir. As part of our licensing requirement, we're required to conduct, forgive me, I can't remember if it's 16, 24, or 32 hours, but there's a certain amount of hours that you have to complete within a 2-year period in order to renew your license. And also for certification, which I maintain through the organization that I mentioned, every 5 years.
Yeah, these are organizations that everybody agrees with each other, but they never go outside of their field to get a actual scientist to agree with them. This is over 100. This is one of these, oh, we have always done it, therefore it's still regarded as evidence. Yeah, but this tool mark analysis is over 100 years old, and the methodology around it, and it was made up at the same time as phrenology, you know, feeling the skull and stuff like that. It's yeah. It's simply shit evidence. But let's hear it, because listen, because according to the defense, there are some acute discrepancies regarding these analysis.
Submit to recertify, and it takes quite a number of continuing.
Different categories of firearms for handguns.
Yes, sir. Handguns differ from the other.
No objection if the court would just give an instruction about what a demonstrative is.
All right, ladies and gentlemen, States Exhibit number 36 and 37 are not alleged to have been involved in this offense at all. It is merely photos, from what I can see from the bench, so that this witness can explain to you about weapons. Does everyone understand? So it's not evidence as a part of this case or for the alleged offense. Does everyone understand? All right, then, without objection, States Exhibit 36 and 37 are admitted.
Thank you, Judge. May I publish, Your Honor?
Yes.
Thank you. Park State Exhibit number 136. And can you please just describe to the jury what this is?
Yes, that is a revolver.
And this type of handgun, would it be able to rotating
their handguns? Yes, sir.
And are these firearms deadly weapons?
Yes, sir. And actually assist in this.
And if you can, just describe to the jury what we're discussing right now about the calibers and the shell case.
For example,
let me show you.
I'm skipping ahead because this is just him explaining what a gun is.
Exhibit number 9. Can you just please take that out of there and view it and tell me what that is?
Appears to be an unfired cartridge.
And this unfired cartridge, I know that you never reviewed it, did you?
No, sir.
But what size is that?
Appears to be a 380.
380.
Although my lighting here is a little hard. I usually look at this under a microscope. So. Does appear to be 380.
Okay, thank you. Now I'm going to show you what's been marked state exhibit number 35. Can you please tell me if you recognize that package
I do.
and how do you recognize that package?
Evidence that's submitted to the laboratory by the agency goes through our evidence receiving section and is issued what's called a CIL, or Criminal Investigation Laboratory number. And that number is unique to any evidence that's submitted that corresponds with the agency case number. So I recognize that I wrote that number that was assigned to this evidence on the packaging, a date that I opened it, initials, and item number that I signed this envelope.
So indicating that and what you just testified to, does that mean that you had contact with this object and that you analyzed it?
Yes, sir.
Can you please take that object out of the packaging of state exhibit number 35? And also pick it out of that packaging. And this is state exhibit number 35, is that correct?
Yes, sir.
Now, what is state exhibit number 35?
35 is a fired 9mm leader caliber cartridge case.
And you say 9mm.
Yes, sir.
Opposed to state exhibit number 109, which is a live cartridge of a 3.8
Yes.
auto.
Yes.
Is that correct?
Yes, sir.
And so there's a marked difference, although the difference is one's a spent shell casing and one is a live cartridge. Is that correct?
Yes, there's other differences as well.
Okay. And well, we explained to the jury what the other differences are.
The main difference being that they are different calibers. As I mentioned, the cartridge case length. The length of the 9mm cartridge case is obviously much longer than the casing of the 380. And although a projectile is not in the 9mm fired cartridge case, generally they're heavier in weight than the 380. And there's usually a slight difference in diameter.
And so you can visibly see that the shell case, or the cell cartridge or casing of exhibit number 35 is at least taller than what the shell casing is for the 380. Is that correct?
Yes.
Okay. I'm going to put it back in 109 and let's go ahead and put back in 135. And if you don't mind, put that back in there. Now, initially, was this shell casing a state exhibit number 35? Were you the first scientist to review it at the Bexar County lab?
No, sir.
Do you recall who that individual was?
Yes, sir.
And who was that?
Was a Mr. Steven Salcedo?
And at this current time, is Steven Salcedo still with the office or the lab?
No, sir.
And do you recall how long ago he left?
I want to say end of 2007, probably 2018, actually. It's been some time.
And so do you have any knowledge of when he reviewed and analyzed the shell casing?
Yes.
Can you tell the jury when he made a final report or a released report?
I can look at my. He actually issued 2 reports, but the first one would have been September 8th of 2017.
And you stated 2 reports.
Yes, sir.
Well, and then what was the date of the second report?
A few days later, on September 22nd, 2017.
Okay, and so let's, in particular, on September 8th, 2017, how do you release it? I guess that you spoke to me about this, but describe to the jury what you mean by release the report.
Can I hold up a report? They can't see what it says, but I just want to show a watermark.
No objection.
Yes.
So this is a type of report that we would release from the laboratory, and you can see this watermark that says released. Keep that in mind. Generally, the way a examination and a review works at the laboratory is thus. We'll examine evidence, we'll take notes, and then we will send that and issue a report, and we'll send that to someone else for review. There's 2 types of reviews. One is a technical review, and one is an administrative review. In either one of those reviews, if you find an error that has been made, you send it back to the person who created it and say, hey, can you fix this? And they'll say yes, we'll fix it, and we'll send it back to you. And in our computer system, it just goes back and forth, back and forth. Now, during that process, and this is what we do in the normal course of business, instead of release, that watermark will say draft because it hasn't been released. It's just still, there could be changes that can be made. Now, once both those technical and administrative reviews are done, the person who wrote the report will release it. Once that report is released and it has this watermark, it's an official copy. So no changes can be made to it. You can't go back and say, oh, I made a mistake or I misspelled something, let's change it. You can't do that any longer because it's an official record.
Ooh. Majesta, thank you, says the Army Research Institute did a case study on ballistic tool marking and found it to be extremely unreliable, with previous studies containing manipulated data. Thank you. I did not know that. The Army Research Institute. If you have a link to that, you can send it to my email. And I just posted the email in my YouTube chat. All right, let's continue.
So part of our quality assurance program, that the way to remedy that, if you find an error after the fact, is to create what's called an amended report to fix that error. So that's why there's 2 reports in this case.
And that's what my next question is, that there was 2 reports in this that were made. Were they both made by Steve Salcedo?
Yes, sir.
And can you tell the jury what the error was on the September 8, 2017 report?
Yes, sir. When we used our system differently back then than we do now, we had to hand type everything. The portion here where it describes the evidence, in his description of the evidence, he listed it as one 40 Smith & Wesson caliber cartridge case, which obviously is incorrect. His notes and everything bear the fact that it is a 9mm. And his results.
I'm going to object to hearsay and confrontation, Your Honor.
All right, that will be sustained.
I'd ask the jury to disregard that last portion of his answer. I'm not objecting to his testimony about the 40 caliber made an error, just the last part about his notes.
All right, ladies and gentlemen, you just to disregard the last question, last answer.
And Mr. Middleton, so then there was a correction made, or I'm sorry, you used the word amend.
Yeah, whoever was the original toolmark analyst could not see the difference between a 40 caliber and a 9mm. That's the reliability of that crime lab.
And that was at the report on September 22nd, 2017?
Yes.
And on that report, what is, I guess, the results, or what was the line that gave what he tested?
Basically, it was changed from description from 40 caliber to 9mm Luger to reflect it correctly.
Now, when evidence comes over from the evidence room, there are certain numbers associated with that. Is that correct?
Yes, sir.
And that's the checks and balances of one checking the numbers to make sure they match with the case number, which is the SAPD number also.
Yes, sir.
And in this particular case was the SAPD number 170-89350.
Yes, sir.
Now, after Mr. Salcedo left, for one, do you even know where he is at currently? If you know.
Honestly, I think he may be working at the Nibin Correlation Center, which is run by the ATF. I think. I'm not certain. He left the laboratory because he really wanted to pursue a different career in some type of business, and so he went.
So he left the crime lab because he wanted to pursue a different career. You know what? Hi, by the way, Nick here. I do labor law, labor and employment law. You know what that is called in this? That is somebody who is being encouraged to fuck off because, yeah, they're not doing a good job.
To work for UPS, but I'm not even sure if he's there. I like Steve, and I just haven't spoken with him sometime.
All right, but thank you. I just try to get some feedback because subsequently you were asked to actually review the shell casing in this case. Is that correct?
Yes, sir.
And that state exhibit number 35, the shell casing in this particular case, did you analyze that shell casing?
I did, yes, sir.
And with your findings, what did you find that shell casing to be?
A 9mm Ruger cartridge case.
And with that particular shell casing, can I ask, how do you review it and what do you look for?
Well, there was additional evidence that was submitted with this. I don't know if I can.
Well, I'm going to go into that, but I mean,
Well,
initially, what do you do with the shell casing? If you just receive a shell casing, sort of like Steve Salcedo, what do you do with it?
the first thing I'm going to notate, obviously, is caliber, and then I'm going to document its class characteristics. Maybe the shape of the firing pin, maybe the structure of the breech face. In some cases, those class characteristics can kind of give us an indication of what type of firearm fired it, because class characteristics belong to a group of firearms. For example, a certain make and model of firearm may exhibit the exact same class characteristics. And so if I had a cartridge case and it had certain attributes that were attributable to, say, a Glock pistol, I could say, oh, this is a fired cartridge case, and it was possibly fired in a Glock pistol. In this case, it was kind of generic, so I can basically just say I couldn't tell you what make or model it was fired in.
Thank you. And as you said earlier, that if this shell casing was maybe fired in a caliber up from it, did you notate anything about any expansion of the shell casing itself or any damage to it?
No, it seemed to be fine.
And then you stated about other evidence, and I'm going to show you what's marked State Exhibit number 135. State Exhibit number 135. Can you let me know, one, is this a firearm in a magazine that you analyzed?
Yes, sir.
And can you just read off the serial number to that?
Yes, sir. It's LEJ9244.
Thank you. Now, since I have this handgun in front of you and the magazine,
I suspect that the defense will say, okay, so you first had a tool mark guy who couldn't spot the difference between a 40 caliber and a 9mm, who shortly thereafter left to pursue who went from being a crime lab tool mark guy to working for UPS. And how can you be sure that a person who can't spot the difference between a 40 cal and a 9mm, that they actually took good care of the evidence? That is what I would have said.
can you hold this magazine, hold a firearm and show the jury how you would load a magazine into that firearm?
As I mentioned earlier about this loading into the magazine under spring tension, but it has these lips on the end, so when the cartridge goes into it, underneath those lips, the first one, it'll catch it. And you can continue to load cartridges under this spring until it can reach its capacity, which in this case is a total of 8. You would then insert it into the magazine like this. You would pull the slide back. That cartridge will pop up. When the slide comes forward, it will load. Now, if you can notice this sticking out just a little bit, it means that even though this is a Smith & Wesson magazine, either it wasn't made for this particular model, or there's more than likely an additional component that goes around this butt area for gripping. But it does work.
And you stated that it's sticking out just a little bit at the end, right? Was this a magazine? Did you use this magazine when you test fired the firearm?
Yes, sir.
And so it was able to be used.
Yes, sir.
And tell the jury what you mean by test firing the firearm.
When we do a test fire examination, I'm going to go through a series of checks. First, I'm going to document the obvious, the make, the model, and the serial number. I'm going to check what type of safety features it has and if they are working, and if it's safe to fire. If it is safe to fire, then I will test fire the weapon twice, either in the range or into a water tank, and recover what we will call our tests or our known standards. We know where they came from because we fired them from the weapon.
Thank you. And in this particular situation, you stated that you did test this firearm?
Yes, sir.
And were you able to obtain the shell casing that was fired from it?
Yes, sir.
show you what's marked state exhibit number.
Were you were you able to locate the shell casing after you fired it in your lab?
138.
And now he's probably going to say yes, it's
And can you please describe to the
match
jury
or something.
on how you would, well, what do you look for on the shell casings to compare shell casings to each other?
The first thing we're going to look for are the class characteristics. These are general. As I said before, class characteristics can belong to a group. So the same 40 Smith & Wesson caliber Glock pistol and the same model number will exhibit, obviously, the caliber is a class characteristic. The shape of the firing pin, is it circle, is it rectangular, is it elliptical? That's a class characteristic. Characteristics of the breech face, are there parallel lines on from the bedding on the breech face? From a bullet standpoint, you would think class characteristics are things such as the caliber, obviously, but also things such as the landing groove impressions that are left on the bullet. How many of them? Are there 6? Are there 5? Are there 7? Do they twist to the left? Do they twist to the right? These are left by the rifle of the barrel. These are class characteristics. If these are different, then from anything we're comparing as question, then we can make the determination. These are
What he is talking about here is the difference between any 9mm gun or the specific 9mm gun. Folks, for the past 30 odd years, when manufacturing weapons like the barrel or the whatevers, these tools can be used. It's practically identical every barrel, and then they change the tool to make new barrels every 5,000 or 1,000. They have the exact same identical things in the barrel. They are being tooled down to the micrometer. So it's not reliable, folks. It really isn't. It can at best be used to exclude a certain type of weapon or a certain,
same. If, however, they are the same, and because class characteristics can share the same group, then we would move into what's called individual characteristics. And these are the fine markings that are left in the firing process of the firearm that are left on the softer metals of fired bullets and cartridge cases. We would first test the weapon, take those 2 tests, and we would use what's called a comparison microscope, which is essentially 2 microscopes that I can view items side by side through one set of eyepieces. I will look on those tests to see if I see markings that are individual that are reproducing from test to test. And if I can find those and say that they are sufficient agreement, then I will see if any questioned evidence have
sufficient agreement. This is where it becomes a subjective opinion, because he looks in a microscope and makes a subjective opinion about, are these similar or similar enough?
those same individual markings. If there is sufficient agreement, then I can make a determination whether or not that item was fired from this particular firearm.
No, you can't.
Thank you. And so I guess at the end, you're saying that if a shell casing is fired from any firearm, it would leave some unique characteristics associated with that firearm.
Generally, not always, but generally.
Okay. And in this particular case, reviewing the shell casing that was fired from the test fire that you did with this firearm, were you able to compare that shell casing with the shell casing that was entered into evidence on this case in State Exhibit number 35?
Yes, sir.
And can you tell the jury whether these two shell casings, were they fired from the same weapon?
They were not fired from. The question, that evidence
oh,
cartridge case
what?
that was submitted was not fired in the firearm submitted.
And is that
okay? That's interesting. Are they going to say that the murder weapon was another weapon than what was found? This was unexpected. So not even this toolmark guy could say it's a match. Yeah. I suspect it. I don't know this guy, so this is just an opinion of mine. I suspect it is because the prosecution is trying to connect the defendant as the person being the actual shooter, and that gun hasn't been retrieved. So they are now excluding another gun as the murder weapon, just to make the reference that it has to have been a gun that the defendant had.
Because of the unique characteristics that you mentioned earlier.
Actually, not individual characteristics. It was an exclusion based on class characteristics. So we didn't even need to get to the individual portion. If this exclusion was based on the class, they didn't share the same class characteristics.
And what do you mean by that in class?
Although they, for example, they share the same caliber, which is a class characteristic, and that's okay. But the shape of their firing pin and the shape of the aperture is the hole which the firing pin sticks out of from the slide. They were markedly different, knowing that they did not exhibit the same class characteristics.
And on state exhibit number 138, is that a photo that was taken by you when you examined these showcases from the top?
Yes, sir.
And the one on the left is which one is that?
The one on the left is the cartridge case from the scene.
And then the one to the right?
That is a test from this firearm.
That you made the test, the one on the right?
Yes, sir.
I'd ask the interstate exhibit number 138 there, just to the defense or any objections? No objection.
State's exhibit number 138 is admitted without objection.
May I publish on?
Yes.
I want to show the jury state exhibit number 138.
And you may step down if.
Oh, I'm going to point.
Okay, all right.
Thank you.
I don't know if he wants to get his steps in today. So, what I'm pointing out right now on this overhead is it's on my right. And which shell casing is this?
That would be one of the tests from the pistol.
That you made a test fire.
Yes, sir.
And this one on the left is the one that was the shell case that was entered into evidence on this case.
Yes.
Okay. And you know what? Actually, Judge, I'm going to ask him to step down and come down here if you don't mind.
Yes.
Mr. Pilton. On state exhibit number 138, can you point out what we're looking at and describe to the jury what the differences you stated earlier on the stand?
I may get my
sure.
demonstrate to see it easier. So when we spoke about this demonstrative yesterday in earlier in the primer, the area we're looking at here is firing pin impression. This is where the firing pin is located. This back area, where it sits flat in the firearm, it's called the breech face area. So it would be a negative impression, the breech face area. Negative impression, or the firing pin impression, in some other areas. This is the area. It's not clear.
And so please describe to the jury, it's that top, that flat portion round. Can you please tell the jury what we're looking at here?
So this is the firing pin impression of the test, and this is the firing pin.
Now this is slightly unusual, that they actually show the pictures of the markings of the firing pin and stuff like that. I've seen a bunch of cases where the judge has allowed the prosecution to not be for this to not be shown, only described, which is absolute bullshit. Since this is an opinion, then any tool mark analysis is a subjective opinion, then it should be up to the jury to look at it and decide for themselves, is this actually a match? At best, it should be excluded altogether, but here we are.
Impression of the questioned. All this area back here, the breech face area. Now, if you notice, there's an area, just think of it as puffy scrapes like this, also around this one. What you're looking at is, okay, that firing pin sticks through the hole in the breech face. This primer is much softer metal. So when it strikes it and that little explosion happens, you're going to have some of that metal filter back into the crevice around the firing pin. Does that make sense? Okay, So now when it gets extracted and ejected, that metal is still in those crevices around the firing pin, and it's going to go at an angle and get kicked out of the firearm, and it's going to make the scraping motion. So that is all of this scraping motions or these striations that you're seeing on this breech face, which is important because this is also a class difference.
Thank you. Can you take a seat back up there? Yes, sir. So, in your opinion, these two shell casings, were they fired from the same weapon?
No, sir.
Thank you. We'll pass the witness.
Defense.
Thank you, Your Honor. Good afternoon, Mr. Pendleton. How are you?
Afternoon. I'm fine, sir. Thank you.
I have a couple of questions about sort of the paper chase here, so bear with me because I want you to try and help me understand a couple of things.
Yes.
Back in 2017, when I believe you said it was Mr. Saucedo was working at the laboratory, is back when this shell casing was first received for your for consideration by your lab, right?
Yes, sir.
Okay. And I'm going to approach real quick. Can you show me the cartridge casing that was originally received back in 2017?
Yes, sir.
So, I should really do need a microscope, don't you?
Yes, sir. And plus the lighting is bad.
But it says at the top, Blazer and then 9mm Luger.
Yes.
Blazer is the brand that manufactures this round. Correct?
Yes. Yes, sir.
Okay. So this shell casing was recovered at a crime scene and sent over to the laboratory. Is that fair, accurate?
Yes.
What happened? And all of that occurred back in 2017 time frame, correct?
Yes, sir.
And have you looked at the chain of custody from when it was first collected at the scene until when you finally received it?
No, so the way it works for us, the chain of custody, the submitting agency will submit it to the laboratory to our evidence receiving section. They will submit a request for analysis. In this case, examine this cartridge case. And from there, it follows an internal chain of custody. So I will go check this out from evidence receiving well, I did.
And let me just stop you right there. When you say internal, do you mean internal to your laboratory?
Yes.
Not so separate and apart from the police department's chain of custody?
Yes.
That's what you mean by internal?
Yes.
Okay. Continue. I mean.
Okay. So I will take it to my laboratory section, conduct analysis, do report, package the evidence when I'm done, and return it to the evidence receiving section, at which time the agency will send someone to collect it.
And take it back to their property?
Yes.
Okay. Now, that's what you do normally. You can obviously speak for what Mr. Saucedo did. You weren't looking at this cartridge back in 2017, right?
I did not look at the cartridge, but it's the same evidence.
Okay. Well, I'm just asking. Back then in 2017, what Mr. Saucedo did with the evidence, you're generalizing now when you talk about the procedures, right?
Well, that procedure was still the same. It has been twice.
Okay. Right. That's what you're supposed to do. Right.
Exactly. Yes. But I can't say
it's done.
Excuse me, if you all could not talk over each other because the court reporter has to type down everything that everyone's saying.
Sorry, Your Honor.
That's what was specifically done here with Mr. Saucedo. You were not an eyewitness to what Mr. Saucedo did.
Yes.
Okay. So, the casing in question, from what you can tell looking at Mr. Saucedo's work, it's a generic brand of ammunition, and the markings on it are fairly standard and par for the course for a 9mm handgun, right?
Correct. Yes, sir.
But at the time in 2017, there was nothing telegraphed specifically. This was shot out of a Glock, or this was shot out of a Smith & Wesson, or anything else.
Correct. Yes, sir.
Okay. And so it gets entered into a database, right?
I believe the police department does that.
Okay. What does the database entail? I mean, in my mind, when you talk about a database, I'm thinking like microscope slides that AI can track and pinpoint and all the rest. But is that what you mean by a database?
Yes. What they refer to, and I don't see any markings as to whether or not it was actually entered, but they may not have done that at the time. But basically, it's called the National Integrated Ballistic Information Network. The National Integrated Ballistic Information Network, or NIBIN. And think of it like a fingerprint system for fired cartridge cases. So digitally, these markings that we were looking at, it's going to use some algorithms and shapes to see if it can find potential associations. Can't be used for identification purposes because you need a microscope and a trained person to do that. But it can give you leads to possible associations, and that's what the system is.
Okay. And you can't say specifically whether that was done for this shell casing or not?
No.
Okay. But from your review of this file that there was no gun to compare it to for a long time.
Yes, sir.
Like 7 years, right?
Yes, sir.
Okay. Now, I'm going to show you some things. I'd like you to help me understand what they are.
Yeah, no gun for 7 years. Even though I believe they retrieved a gun. So there were nothing to compare with for 7
Your Honor,
years.
may we approach?
Yes.
Sorry.
That's okay. All right. It's the court's understanding that a juror needs a break. I'm sorry, I didn't see you signal. Remember my previous instructions, and I will have you all back here. Is 4:55 enough time for everyone? All right, everyone, please rise for the jurors.
And that makes it sidebar counter 32 on day 6. More than 5 sidebars per day, and 2 of them were half days. Oh. Oh, wow. All right, let's skip it. I wish we could hear them, but she turns off the sound during breaks. And I guess now they are coming in again.
In your laboratory ago, we were talking about how that 9mm shell casing arrived at the laboratory back in 2017.
Yes.
And then there was a long period of time where there wasn't a gun in your laboratory to match up to that, right?
Yes.
And you were asked to test a firearm against that shell casing in what, the late summer, early fall of 2024, correct?
Very recent. Yes, around probably a little before, but my report is issued on September 12th of 2024, so probably wouldn't have been too long.
Okay, fair enough.
Oh, August.
I don't know what this is, but I want
Okay. Also, it's also that he can recognize.
Yeah, he doesn't. I'm not playing at all. Okay. I want you to help me kind of just understand what I'm looking at here and what you can tell me about it. I'm going to first show you defendants 11. And if you could just take a look at all the pages of 11 and tell me what that is, if it's anything, and if you recognize it.
Can't see the actual numbers. It looks like page printouts from our old system from 2017. But yes, I recognize them.
Oh, okay, so when you talk about page printouts from your old system, there are a series of sort of drop-down menus like you would fill in a PDF with?
Yes.
Okay, so there would be options to click underneath all of those things?
Yes.
So someone has printed that screen as to what was entered with respect to this case, this one fired 9mm linear caliber cartridge case.
Yes.
Okay. Now on page, and you reviewed these materials when you were preparing your report?
No, because these are the older. I believe these look like they're from the previous version of what I'm using now.
Okay.
That's why I say I can't see the numbers or dates. So I don't know. Is this mine?
If you can look there, does that indicate to you that it might have been from 2017?
The date started. Yes, it does look like it's 2017 date started. So this is like.
Okay, so this would have been the stuff from the original work that Mr. Salcedo did.
Yes, and to be fair, at that time, this system, we really didn't utilize that portion as much. It was more the handwritten at that time that he would use.
Okay, so I'm going to call your attention to page 3 of defendants 11, and I want you to talk to me about this stuff here. This is Mr. Salcedo's notes about the cartridge casing, right?
Mm-hmm. It appears to be, yes, sir.
Okay, but like the report that you mentioned, he's indicated that it's a 40 Smith and Wesson
Yes, he did.
on that document,
Yes,
right?
sir. Yes, he did.
Okay, and that would be in keeping with what I'll show you as Defendants 14, which was the released report that you were referencing earlier,
Yes, sir.
where he also states that it's a 40 caliber Smith and Wesson.
Yes. Correct.
Okay, and you were telling me a moment ago that in the remarks section of Defendant 14, where it says these items will be returned to the evidence receiving section, that your policy has been updated.
Yes, sir.
What's changed now?
If an amended report were to be issued today, it would still say at the top of the report, this is an amended report, but at the bottom in the remarks section, it would have some type of notation that would say, this report has been amended to change this to this, and it replaces the report of the previous one, whatever that date would be, something to that.
So explaining and referencing the prior report that's being changed.
Yes, sir.
And that would just be so that there's no confusion about whether we're looking at the same piece of evidence.
Correct. Yes, sir.
Just to be clear, when it says here, there's a 1-1 and it says one fired 40 Smith and Wesson caliber cartridge case, and then E1. 1-1 and E1, are those your internal numbering systems for the evidence?
The 1-1 is the our numbers. The E1 would be what would be on that's the agency number.
Okay, and you're not aware of how the agency does its numbering system or whether there are any other E1s or anything else?
Absolutely no, sir.
Okay. Now, ultimately, I'm going to show you Defendants 13. These are your notes from last year. Is that right?
Looks like it. Yes, sir.
Okay, so this would be your work without Mr. Saucedo's involvement.
Yes, sir.
Okay, you did go back and look at Mr. Saucedo's involvement, right?
Yes.
Did it inform your opinion in any way?
No.
Okay. Now, you mentioned earlier that this particular shell casing that we were discussing here, which is in, yes, that states. Jason, the nine from the scene is which evidence number? Okay, about 35. There we go. So states 35 is the original shell case.
Yes.
Okay. And then states 109. Okay, no, I'm sorry. This is a 380 auto bullet, right?
Correct. Gunfire cartridge. Yes.
Your understanding was this was found somewhere in conjunction with the case?
I assume I have I've never seen it before.
Okay. Now, Mr. Garahand asked you if you could fire a 380 auto in a 9mm gun. Gave that explanation. Right?
Yes.
What about the other way around?
Can a 9mm be fired in a 380?
Right.
No, sir.
That's not possible.
No, sir. It's too large and too long, so it won't fit into the chamber.
Okay. So if somebody has a 380 pistol and they tried to load a 9mm bullet into it to shoot it, what would happen?
That would more than likely jam. If it would even fit in the magazine. If it did, you try to cycle it, it would basically lock up.
Okay. Now, when were you made aware that there was a gun that that needed to be compared to that 9mm shell casing in States 35?
I don't have the submission form, but normally on reports, we put when it was submitted. So as of August 28th of 2024, so probably about a month, a little less than a month before I issued the report.
And do you know anything about the story of that gun that you were asked to compare to the shell casing? In other words, how it arrived at your laboratory?
I know a little now after the fact, after speaking with Mr. Garahand for pretrial, but before that, no, I did not.
Okay. Now, so at the time that you were doing the comparison, you were unaware of anything other than just here's a 9mm pistol, it's a Smith and Wesson. We're asking you, can you compare that to a shell casing we recovered at your crime scene?
I believe so. I can't say for certain if I had maybe got an email to work the case and that information. I'm not absolutely certain, but I don't believe so.
Fair to say, there's nothing in your notes or your work about the analysis or the comparisons that you did where you listed that as a factor that would have impacted your analysis?
No, of course. I think I might have notated there was something about Dallas PD or something.
So you've since come to learn that the gun was in Dallas for some time and then came to San Antonio for some time, but never just got linked up with this case or the shell casing until not even a year ago.
Yes.
Okay. So when you did your analysis, you took was it the same brand of ammunition?
No. No. Just forgive me, these computer printouts are a little bit harder to read when they're on the screen. Actually, yes, I did use the same brand of ammunition.
which is Blazer,
Blazer, yes, sir.
Blazer 9mm Luger ammunition.
Yes.
Okay. So,
Did you use ammunition that was manufactured the same year? This was way back in 2017. Had Luger made changes between 2017 and 2024? That's something you should count in, right? Right?
and you did that to just try and eliminate as many variables as you can from your analysis, right?
Yes.
It's the way that a firing pin indents, say, a Winchester 9mm round might be different than the way it impacts a Blazer round.
Yes, there are going to be very slight variations, but there can be variations. So just to alleviate that, when possible, if we have our own ammunition collection, we prefer to use ammunition that from our reference that is as similar or close to as possible to any questioned evidence. That does not mean that if they submitted unfired evidence and I couldn't use it, we just prefer to use our own ammunition because we know there's no previous markings on it.
Okay. And so we understand from that idea that there are variables that can affect our ability to say things with a lot of certainty about how a primer is indented by a firing pin.
Yes.
Okay. And so you ruled out this gun as being the source of that spent shell casing based on what you call class characteristics, right?
Yes.
So no microscopes are involved in this kind of work.
Well, there are microscopes involved, but they're just not a high power, and we're not comparing individual comparisons.
Sure, you're like we were having trouble reading the word
Yes.
Blazer on that.
Absolutely.
Okay, so the microscope can help with that kind of stuff, right?
Yes.
That's the level of magnification we're talking about.
Yes, as a matter of fact, if you notice the photo, it's still on the screen. It says micro B. That stands for microscope B. That's the microscope that I use. And F14X means it's 14 times.
Okay, gotcha. So in terms of the variables that can affect the primer indentation, I mean, you're familiar with guns. You've been out to a range and fired multiple rounds through a gun, I'm sure, many times.
Yes.
And you've probably experienced the frustration any gun user has experienced where you buy a brand new box of ammunition and a round doesn't go off.
Yes.
So there are variabilities in the manufacture of guns,
Okay.
of ammunition, sorry.
There can be, yes.
And that could include how the primer is seated, or whether the primer has been exposed to corrosion before it got put in the box, or
Yes.
probably a lot of other things.
Yes.
Okay. And so when you're talking about ruling things out on a class level, you said that caliber is one possible way to rule it out on a class level.
Yes.
Okay. So like, for example, if we have a 9mm cartridge, or I'm sorry, we had a 40 caliber cartridge casing and a 9mm pistol, you don't have to do any additional work to say that on a class level, that's not possible. That's not the gun that fired the cartridge.
Yes.
Okay. But you said that also things like primer could be, right? A class of characteristics.
So the firing pin shape and the aperture shape is what I was referring to. Yes, sir.
Okay. And so, like, for example, some guns are manufactured in such a way that they leave a distinct signature on their firing pin, right?
Yes, so there are some that if you were to see that firing pin because you're accustomed to seeing certain makes and models, you test fire, you look at the test. There are times where you can pick up a cartridge case and go, oh, that's from this type of gun.
But not all guns are that way, right?
No. And actually, most of them aren't.
Most of them aren't. In fact, some gun manufacturers have been criticized publicly and in lawsuits because they don't make their firing pins more distinct, right?
There's a debate about that, yes, sir.
Okay. And I mean, part of that debate goes to just generally the idea of using a firing pin indentation like a fingerprint, right? There's some criticism of that.
In that respect of really what you're referring to is micro stamping, the imprint. What they're referring to is putting a serial number very microscopically on the firing pin. So if it were to strike an object, you would have that serial number and say, oh, well, this was fired in that gun. It's a little more complicated than that. And also, they don't, part of that debate, which I don't really want to get into the debate, but part of that is they don't last very long.
Understood. So, okay, when we're talking about, we're talking about a mechanical tool. A gun is a mechanical tool, right?
Yes.
And all of the parts of a gun are working against each other and principles like friction and so forth, because it's metal rubbing up against metal to make this thing work.
Yes.
And so guns have ordinary wear and tear as a consequence of that, right?
Yes.
If you take a shotgun and you open it up for the first time out of the box, it's probably very stiff and difficult to open. But if you've been shooting it for 40 years, it could just almost fall open with a tap of the hammer, right?
Yes, and that wear and tear will also add to the individual and accidental, what we call accidental loss. Yes, sir.
And so as a gun wears, that can impact how the firing pin works, correct?
Potentially, yes, sir.
Okay. And then other things might impact how a firing pin works on a specific occasion, like the gun shot upside down or sideways or.
Folks, I think here the defense is, I don't know how this is useful for a jury. I mean, this is sometimes, and I get this on a few occasions when I am discussing my area of law, is I tend to get overly technical, and because I forget sometimes that most people are not on my level of understanding on my area of law, and I think we are a bit overly technical here. It could have, yeah, I agree. He's putting some doubt into the equation. I agree. But he can do it so much simpler, in my opinion.
At an unusual angle other than what a marksman normally goes for, right?
Potentially, yes, sir.
If a gun was dropped or damaged in some way, that could also impact how the firing pin works.
Good, yes, sir.
As far as corrosion is concerned, these are, again, metal objects, right? I mean, apart from what, the grip, everything on that gun is metallic in some way.
Yes, they're usually stainless steel. Yes.
And so a gun owner has to take care of the gun, oil it, lubricate it, remove powder and other debris on a routine basis, or else the gun might start to rust or jam, right?
It depends, maybe not necessarily rust so much, but continued dirt and debris and stuff may make it operate not properly, yes.
And certain materials may start to cling to aspects of the gun because there's oil and grease on it, dirt, grime, gritty material, sand, those kinds of things could get in it, right? And so if something has been sitting for a very long time and has not been cleaned or maintained, you would expect to see some kind of problem with the gun generally, right?
Depends on the environment.
Okay.
If it's just sitting in a drawer, I doubt any change is going to take place.
And to be fair, you don't know a lot about the story of this gun and where it's been.
No, sir.
Okay. And that was not something that was reported to you when you did your analysis.
No, sir.
Okay. And those kinds of issues related to corrosion or grime or issues with that could affect the firing pin's operation.
They could, but it's also one of, like you spoke of, the many variables. Those are also variables that we consider in parts of our examination.
Okay. So am I to understand that when you're looking at states 138, is it on the
Yes, sir. Yes.
when you're looking at 138, the thing that you discussed at length with Mr. Garahan was the breech face impression, which is the sort of broader ring around the really fine pointed indentation on the primer, right?
Yes.
The fact that the one on the right seems to have a larger gouge dug out of it on the right, you didn't seem to mention that. That doesn't seem to be a major point of interest for you.
No, it is. It's actually clear. It would be easy to show the actual firing pin of the weapon to explain why there is a unique shape to the test that isn't being shown.
Okay. Did you do any disassembly of this gun?
No.
Okay. So that wasn't something that you notated in your report?
No.
Okay. Were you aware that the gun had been entered into the database up in Dallas?
Possibly. I think there was some notation on the paperwork, possibly. I can't say yes or no, but it is a possibility, yes, sir.
And that didn't play a role in your analysis at all?
No, sir.
For them to have made that entry in the database, they would have had to fire an exemplar shell themselves up in Dallas, right?
Yes, sir. In order to enter a cartridge into the, well, if it for the gun, they would test fire, yes, sir.
Okay. And you have not seen that exemplar spent shell casing?
No, sir.
Okay. And you didn't review the notes that were in the database about that spent shell casing in your analysis? You based it off the exemplar you made firing the gun in your laboratory?
Correct, yes, sir.
In a case where there's this much time between when a gun is alleged to have been fired, when the gun was seized, and when the gun finally got tested, would it be helpful scientifically to see what an exemplar taken from the gun earlier in time, closer to the time of the shooting, would have revealed?
Not necessarily, especially not in this case, no, sir.
Well, you say not necessarily, but it would be a variable, right?
Potentially, the changes to firearms have been shown study after study to be very minimal over time, lacking some form of forced change.
But you're aware that there are also studies that have said that analysis based on primer indentation are unreliable because they're difficult to repeat, right?
Yes, sir.
So, I mean, your field isn't without some scientific criticism.
Absolutely, yes, sir.
Okay. I'll pass it on.
State?
Yeah, Your Honor.
Yes.
Mr. Pendleton, you were, when Mr. Hunter was asking you a question about the indentation and everything, the firing pin, you stated that you could show with that particular firearm, I guess, a unique characteristic of this firearm. Can you explain that to the jury?
Oh, for
Yes,
fuck.
the,
Oh, for fuck's
with
sake.
the Smith & Wesson M&P, I mentioned earlier that aperture, that circle that the firing pin sticks out of. In addition to that, there is call it a scoop or a piece of metal that is taken away from the breech face area around it, or in a portion of it, and that is put there by Smith & Wesson, they claim, to help assist in debris when you fire the weapon, fire powers and stuff to not collect, gives it an escape route, so to speak. And when they put that there, when you fire a cartridge case into it, when I mentioned earlier, the softer primer kind of flows back into the crevice area. Well, it also fills in that area. I'm trying to find a hard word to explain it, but it basically makes this shape here on the end, if you can see what I'm seeing. And that tells me that this cartridge case, and I know that for a fact because I fired it from that gun. This is a test. Was fired a make and model type of Smith & Wesson. There's also a Glock that can have similar distinction because they do the same manufacturing technique, but that is not on the questioned evidence. Another change here, and I failed to mention it earlier, I apologize, but the firing pin itself, if you were to look at it from the profile, the test is what we call a hemispherical. Think of a globe, you cut it in half, it'll look like a bowl. That's the tip of the firing pin. Think of it like a bowl shape. Whereas the questioned one has more of a flattened surface. That's what we call a circular firing pin. It's a little tapered on the edges, but the base of it is more flattened. So these are class characteristics that are different from each other.
And with this particular weapon, did you notate any corrosion or any other variables that Mr. Hunter had mentioned?
No, sir.
Thank you. We'll pass it over to you.
Very briefly. You didn't notate that there wasn't, right? Okay. And you mentioned that there are certain aspects of this manufacturer's breech face that are significant to you, but you don't notate those in your report either, correct?
Well, actually I do, but you have to be an examiner understanding the notations. Like if you look at my notations, I'd say the firing pin type. I have to look at my notes, but I'm more than likely call it a teardrop because we generally see that shape, and that's kind of the shape that examiners have called it. Personally, I think it looks more like a comet, but we go with teardrop. Whereas this other one, I would notate that it's circular. Also with the firing pin impression, in my notes, you'll notice that it will say M&P because that's the type of firing pin impression that I typically see in M&P. Whereas this other one, the notation for it will say circular. So it is notated, but it's very difficult to understand what those notes mean unless you're accustomed to writing those notes.
Okay. Now, you mentioned that it's a teardrop shape on the right-handed breech face, right?
Yes.
Now, on the left-handed one, that is the one that was collected as questioned evidence, there's also more of a cutout, if you will, or an indentation trailing off to the right in the same direction as on the 2024 test, right?
Those actually are not from that type of, that's actually part of the firing pin. It's called the firing pin drag. And they don't always have to be the same, even from make and model, same make and model. And what's happening is when the firing pin strikes the primer, it's going to stay stuck inside it a little bit. And so when it's getting kicked out of the weapon, it's going to kind of scrape its way out of there. And it leaves this marking here and this marking here on this one. So it's called firing pin drag.
So your belief is that the shell casing on the left is exhibiting firing pin drag, and the shell casing on the right is exhibiting a different shaped firing pin? Is that not
No, they are both exhibiting firing pin drag. They are, however, the firing pins themselves exhibit different class characteristics.
Okay. Well, I understand they exhibit different class characteristics, but you were specifically calling our attention
Oh,
to
yes,
that
they're both,
aspect of it. They
they're
both
both,
have
they
drag.
both have drag, yes, sir.
Okay. So the degree that how many total class characteristics are you supposed to go through in doing a comparison?
You know, honestly, there's no set number. No one's ever asked that, but generally it's the caliber, the shape of the firing pin, and characteristics of the breech face.
So
There's a number of different types of shapes to look for on a breech face, but it's,
so the things that you believe would fall into that category of class characteristic may differ from another examiner.
no,
Okay, but there's no set number of things that could be a class characteristic.
there's not a set number, but I would, in other words, another examiner would not look at this and say that that's not a class characteristic.
Okay,
Yeah,
well,
that's not the question he asked. He was asking about the number of class characteristics. Yeah, there's no basic guideline. It is a subjective opinion. So when he says, oh, another would also say these are class characteristics. Well, that's not the question here, Mr. Mr. Toole. The question is, would another examiner look for the same amount of class characteristics as you, or would he settle for a number lower than the one you are using or higher?
it sounds like it's a fairly broad definition. Like, would you agree? The idea of class characteristics?
It obviously, to be fair, it depends on what the item of evidence is that you're looking at.
Okay, and fundamentally at its core, because these are observations that aren't using extremely high magnification examination, there is a degree to which the training and experience of the examiner plays a role.
Absolutely. And to be fair, everything that I do is subjective. I mean, that's my opinion.
Ask witness.
No question, John.
All right, is this witness excused or subject for recall?
Excused by the state, Your
Honor. Excused by the defense.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial. Thank you. All right, and state, is that your last witness for today?
Yes, it is, Your Honor.
All right, so ladies and gentlemen, I'm going to have you back here tomorrow at 9:15. I know previously I said 9 o'clock, but I want to say 9:15 to make sure that everyone has a chance to park. We can go off the record. And remember previously what I told you about the number of jurors who will be coming up. The same number of jurors when you all were brought up are going to be the same number of jurors for tomorrow. All right. And remember my previous instructions. Do not do any investigation. Do not even think about this case outside this outside this courtroom. Does everyone understand? Do not deliberate. Do not talk about it. Everything that you need to know about this case has come from inside the courtroom. All right. All right. And I don't think there's any street closures, but you can Google that and check that to make sure that there are no more street closures downtown. I think, well, I know the basketball game is done. I don't know if people are still here for that, but I don't know of any other closures. So before you leave, you may want to check to be sure. All right, everyone, please rise for the jurors.
Okay. I'm not sure if they are doing a full day or a half day. That is not mentioned, of course. All right. I think I have another hour in me. So let's go directly to what happened. Sorry. Sorry. Sorry, I had to cough. Let's go to this morning. And do another hour.
Her mother, and then I have a couple.
Oh.
Mm-hmm. And she's doing some morning docket before everybody, before the trial actually commences. And here they are. Let's see.
Oh, Judge, I'm not. You're not ready. Yes.
Okay, here's our judge.
Okay, we're ready. Yes.
I have
All
closed.
right, for the jury?
Oh, Judge, I'm not. You're not ready? No. I'm trying to get the mics ready.
Yeah.
Okay.
This case is from 2017,
All right, everyone, please be seated.
and some of them wear masks to this day. I don't know. Yeah, and if you just joined, welcome, and hit the like button while you are here. We are checking the State v. McIntyre out of Texas. Mr. McIntyre is charged with capital murder. He cannot be sentenced to the death penalty because he was a minor at the time. And it's interesting, to say the least.
Don't rush. When you rush, it just takes longer.
Skip.
136 and 137.
Any objection?
No, Your
Yesterday, the witness David Pendleton, state offered states exhibits 36 and 37, which were admitted into evidence, but we are moving to renumber them as 136 and 137.
Any objection?
No, Your Honor.
All right, then,
Objection to the video.
Then, ladies and gentlemen,
We're demonstrative.
ladies and gentlemen, states exhibit 36 and 37 will remain the same content, but they're just renumbering it. And so 36 will now be 136 and 37 will now be 137. Does everyone understand? All right, state, call your next witness.
Just really quick before the next witness, at this time, the state offers states exhibits 59, 60, and 61, which were authenticated through Officer Halliburton, and defense has previously reviewed the exhibit.
No objection.
All right, states exhibit 59, 60, and 61 are admitted.
Thank you. The state calls Christina Vachon.
Okay, so now it's just evidence they all can kind of hopefully agree on. Saves time. Hard to tell.
Could you raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you may have a seat.
What's your name, cutie pie?
All right, if you make sure that you keep your voice up so that members of the jury can hear, and also if you could state your name and spell your last name, please.
My name is Christina Vachon. My last name is spelled Vachon.
All right, state, you may proceed.
Thank you. Ms. Vachon, how are you currently employed?
I am currently employed as the Quality Assurance Manager at the Bexar County Criminal Investigation Laboratory. I've been in that position for about 5 years now. And for the 15 years prior to that, I was a forensic scientist in the trace evidence section.
All right. And as a forensic scientist in the trace evidence section, what were your duties in that position?
I would examine items of evidence that would come into the laboratory. They were generally microscopic, but not biological in nature. So I would examine items such as fibers, did hair comparisons, paint, gunshot residue, footwear and tire tracks, did a lot of different types of testing.
All right. Can you explain to the jury your educational background?
I have a bachelor's degree in biochemistry and a master's degree with a concentration in forensic science.
All right. And as a forensic scientist with the Bexar County Crime Lab, did you receive any specific training regarding gunshot residue?
Yes, I did.
Can you explain that to the jury?
Yes. I attended the Lehigh University School of Microscopy for training on the instrument that we use. I also received training from the manufacturer of our instrument on the software that we use. And I received training in-house on the type of testing for gunshot residue, and that included reading journal articles, conducting supervised casework, and then passing written and practical exams before I was released to do my own casework in gunshot residue.
Okay. And have you testified as an expert witness in the area of gunshot residue before?
Yes, I have.
And has that been including in courts in Bexar County, Texas?
Yes.
Okay. Now, regarding the Bexar County Crime Lab, can you explain to the jury if the lab has any credentials or certifications?
We are accredited.
Okay. And in the Bexar County Crime Lab, do you have the ability to conduct
we don't
exhibit number 17 at the Bexar County Crime Lab?
The chain of custody is retained in our laboratory information management system. It's a database software system.
Okay. Now, regarding the state's exhibit, did you receive that at the Bexar County Crime Lab?
Yes, I did.
Do you recall what date you received it?
I mark the item of evidence whenever I receive it, and I mark this as May 23rd, 2017.
Okay. And do you recall who you received that from? Was it an agency or?
The evidence was received into the laboratory from the San Antonio Police Department.
Okay. And Once the evidence is received into the Bexar County Crime Lab, do you know where it goes?
Yes, it is kept in the evidence receiving section of the laboratory in the vault there until I'm ready for examination. And then I will take custody of the evidence and take it to our scanning electron microscopy room, which is where I do bench RSV testing.
Okay. And so in this case, did you personally obtain the state's exhibit for testing on May 23rd of 2017? Would it be marked on the exhibit?
Yes, I did.
All right. Did the kit have any unique identifiers on the packaging when you received it?
Yes.
Do you recall what those would be?
All items of evidence that we received from the San Antonio Police Department have a barcode that is related to the agency number and the type of evidence.
Okay. And so the barcode on the state's exhibit, can you please read that?
Your Honor, at this time, we would renew our objections as to hearsay and confrontation based on the predicate wasn't laid about Kim Wong.
All right, that objection is overruled.
You may read it. Well, and Judge, if I could just respond, this kit and sample was obtained by Catherine Andrews Imler, who did testify in this case, so that's my response.
Yes, Your Honor. But Ms. Andrews turned the scene over to Ms. Wong in process.
Excuse me, just 1 second. Excuse me, why are you all here?
Oh, he needs to come back here, Judge.
All right. All right, please be.
Okay, so now there are if you haven't seen the first few days, they are talking about Ms. Wong, who was back in 2017, 2018 or something like that, was in the crime lab. But she nowadays is nowhere to be found. She quit her job and moved abroad. The prosecution claims they can't find her, that she can't be on Zoom to testify about the evidence she tested. And so they are having different witnesses talking about her testing and her interpretation, which for me, why? It's the state's responsibility to bring forward the correct witness. If they can't, then why should the defendant suffer from that? Because if somebody is deceased, another story, but Miss Wong is alive and well, but abroad. And for some reason, the prosecution can't get a hold of her and have her testify via Zoom.
All right, so ladies and gentlemen, the gentleman who came in has absolutely nothing to do with this case. Believe it or not, back there are restrooms, there is plumbing, and there may be an issue with the plumbing in the back, and we don't want any floods coming into the courtroom. So completely ignore him in the sense that it has absolutely nothing to do with this case. And there's no other entryway for him to come there other than here. All right, so state, what were you stating?
Well, I was just responding to his objection. State's exhibit that the witness has was personally collected by a witness that testified, which is Catherine Andrews.
All right. And
our only response is that while we don't dispute that Ms. Andrews is the person who did the swabbing, the barcode, the question was asked to have read into the record, was generated by another witness who's unavailable.
All right, that objection is overruled.
All right, could you please read the San Antonio Police Department case number on the state's exhibit?
It's 17089350.
And when you receive evidence at the crime lab, is it assigned a unique number within the crime lab for tracking?
Yes, it is.
And what would that be in this case?
In this case, that was 17-03268. And sometimes we do get separate submissions with different types of evidence. This was submission 2 that came in on with this agency number from the San Antonio Police Department.
Okay. And regarding the, did you get any information of who the kit was collected from?
Yes, it was labeled as John Doe on the outside of the kit, but the submission form that is filled out by SAPD and comes in with the evidence listed the kit as having come from.
Same objection, Your Honor.
Overruled.
The submission form.
I agree with the defense here. Sorry, Judge Boyd, because the only person who can testify to that John Doe is the same as the named is the person who actually did it. And that person is unavailable. I don't like this.
Identified the person the kit was collected from as Mark Anthony Saldivar.
Okay. And when you take the kit into your custody, do you do any visual inspection to ensure there's been no tampering on the kit?
Yes, all items of evidence that come into the laboratory have to be tape sealed. So I ensured that the seal and the package are intact.
Okay. And so on May 23rd of 2017, did you analyze the contents of the sleep exhibit 17?
Yes, I believe I received the evidence on May 23rd, and then I actually did the analysis on May 30th.
Okay, thank you very much. And on the day that you conducted the analysis, were you forensic scientist employed with the Barry County Crime Lab?
Yes, I was.
And regarding State's Exhibit number 17, did you put any unique identifiers on there for your knowledge to ensure that it's the same thing that you conducted the analysis on?
Yes.
What would that be?
Every item of evidence that I take into my custody, I will write the criminal investigation laboratory number, the date that I receive it, the item number, and my initials. And then whenever I have completed analysis, I will make a tape seal and write my initials and the date that I seal it. And I see both of those here.
Okay. Would you please explain to the jury what gunshot residue is?
Yes, I have a model if I may use it.
Your Honor, and defense counsel, the witness has a demonstrative, but she does not wish to leave it here and for it to be entered into evidence after she'd be able to use it.
No objections to the use or preventing its admission. She can
All right. Yes, you may proceed.
This is a model of a round of ammunition, and you may have seen it with the firearms examiner as well. I'm going to show you something different with it. So what happens whenever a trigger is pulled on a gun, it will release the firing pin of the gun. The firing pin will strike the primer cap area that you see here, the silver area, and that contains shock-sensitive chemicals. So whenever it receives that strike from the firing pin, there will be an explosion in this primer cap, which blows into the cartridge case area of the ammunition. Inside the cartridge case, there is nitrocellulose, gunpowder, and that will ignite and burn very quickly, and the gases expand inside the cartridge case. And it's those expanding gases that actually push the bullet out of the cartridge case and down the barrel. So whenever I am looking for gunshot residue, I'm looking for the components of the primer cap area. And it contains the metals lead, barium, and antimony. And those will evaporate in the explosion and then condense back together to form particles. And those particles are forced out of any open areas of the gun, and they will land on surfaces around the gun when it's fired.
Okay. And the analysis, how do you conduct it? With what instrument?
I use a scanning electron microscope with an energy dispersive X-ray detector.
Okay. And what would the analysis reveal?
The analysis allows me to identify individual particles on the surface of the sampling device. And if they contain lead, barium, and antimony during the automated analysis, then I will go back and confirm that composition. I'll look at the shape and size, which is also important. And then I'll be able to confirm that gunshot residue was on that sample. And it will allow me to make conclusions as to whether a person possibly handled or discharged a firearm.
All right. And now, so when you conducted your analysis of the state's exhibit, did you prepare a report that reflected the findings?
Yes, I did.
Of your analysis. And just regarding, did you follow all the protocol regarding the instrument when you conducted the analysis?
Objection leading.
Overruled.
You can answer.
Yes, I did.
And once you were finished conducting your analysis, what did you do with the evidence?
The evidence was returned back to the evidence receiving section of the laboratory, and then it was collected by a representative from SAPD.
Show you what has been marked as State's Exhibit number 139. You could take a look at that and tell me if you recognize the document.
Yes, I do.
Okay, is that a copy of the report that you generated in the case?
Yes, it is.
Okay, does it reflect your findings of your analysis?
Yes, it does.
Okay, and was it created, State's Exhibit number 39 created at or around the time that you conducted your analysis?
Yes, it was.
And are you a custodian of records for the Barry County Crime Lab?
Yes, I am.
Is State's Exhibit number 139 a true and accurate copy of the report and the findings?
Yes, it is.
And just regarding, is that your signature, or electronic signature on the report?
Yes, it is.
And is this report kept in a record for significance?
Yes, it is.
You're tendering to defense for inspection at this time and offer receipts in 139.
No objections.
All right, State's Exhibit number 139 is admitted without objection.
Permission to publish.
Granted.
All right, Ms. Bashan, so I am publishing State Exhibit number 139, which you've stated is a copy of your report. Can you please explain to the jury what the result of your analysis was?
I identified 10 microscopic particles containing lead, barium, and antimony on the sample that was collected from the right hand of Mark Anthony Saldivar. And I found 10 particles containing lead, barium, and antimony on the sample that was collected from the left hand of Mark Anthony Saldivar.
And is there any significance in the microscopic particles?
Yes, I will confirm up to 10 particles on each sample. So that means that there were possibly more than 10 particles on these sampling devices.
Okay. And so based on the identification of these particles, what was your finding regarding Mark Anthony Saldivar?
My conclusion was that based on the morphology and elemental composition of the particles I found, Mark Anthony Saldivar may have discharged a firearm, handled a discharged firearm, or was in close proximity to a discharging firearm.
Okay. Now, in your training and experience, have you examined gunshot residue kits for victims of gunshot wounds?
Yes, I have.
Okay. And is it common for victims that suffered a gunshot wound to have gunshot residue present?
Objection relevant.
Overruled.
You can answer.
In my experience, it is very common for victims of gunshot wounds to have gunshot residue on their hands.
And why is that?
It is because as I said before, it's the force of the gases that are pushing the bullet down the barrel of the gun and toward the target. So most of the gunshot residue is going to be forced in that direction because that's where all of the pressure is going. So whenever a gun is pointed at a target, then a majority of the gunshot residue will be traveling in that direction toward that target. So if a person is being shot, it would be common sense. It would make sense for them to have gunshot residue on them if they're close enough to the gun.
Okay. And you can't definitively say, right, because you were not a witness in the case, but you can't definitively say whether the victim discharged a firearm or not. Is that correct?
Correct.
Okay. Hypothetically, in your training and experience, if somebody was wrestling with a firearm, would that result in them having gunshot residue on their hand?
That is possible. One of my conclusions is that the person may have handled a previously discharged firearm. And if they are struggling over a gun, then they would be touching the gun.
We have witness on
Defense.
Thank you, Your Honor. Good morning. How are you?
Good.
A couple of things. Your conclusions were that either he fired a gun, he handled a gun, or he was in close proximity to a gun being discharged, right?
Correct. Those are all ways that someone could get gunshot residue on their hands directly from the gun. They are the most likely, but they're not the only possibilities.
So the analysis you performed doesn't weight those possibilities. They're all equally as likely based upon what you know about the circumstances of what you received.
Correct.
Okay. And we can't really, in an ethical way, scientifically, try to apply more weight to one or the other. We can't just shoot someone and see how much powder is left on them, right?
Correct. And all guns and ammunition and crime scenes are different. So you wouldn't even be able to repeat what happened at a crime scene in the lab to determine how much gunshot residue someone should have on.
And in terms of the possibility that they were just in close proximity to a firearm, in other words, they got shot by a firearm and that's why they have residue, that would depend on how far away they are from the gun, right?
Partially, but there was a study conducted that postulated that there is possibly a supersonic wind that travels behind a bullet that gunshot residue can travel in. So that residue can be deposited on someone that's further downrange. But generally, gunshot residue will stay in the vicinity of the gun where it is fired.
And so there's a study that is considering that as a hypothesis, but it hasn't been established as a well-recognized practice or thing to rely on in your field, right?
Correct.
Okay. You indicated in your remarks that it would be recommended that a known firearm and ammunition be submitted if further testing is desired. Would that be because it could be conceivable to look at the concentrations of lead, barium, and antimony in the shell casing residue and compare that with the concentrations that you find on the subject, on the deceased's hands, and see if there are similarities, for example, in the mixture of the gunpowder for that particular brand of ammunition?
So these particles are heterogeneous, which means that they won't have the same concentrations of the different elements in them in every particle. Sometimes we do see ammunition that has an additional element in it, such as copper or tin, that we can see in the particles. And sometimes it might be helpful to try to connect that back to the ammunition that was used in the crime that's being investigated. But generally, we have that statement there for cases where gunshot residue is not found. And we would be able to do a test fire to see if the gun actually expels gunshot residue, what type of gunshot residue comes out of the gun, because it doesn't always have these lead, barium, and antimony components. So it could be done in this situation because we did find 10 particles, because I did find 10 particles on each sample. I would not have recommended it.
Okay, but this is your report, right?
Yes.
And it is the final released version of the report, meaning that you're not going to be able to amend it later. This is what goes into evidence, right?
Yes.
And those remarks are on State's Exhibits 139, right?
Correct. Those are standard remarks that go out in every gunshot residue report.
And that kind of testing could have been done, right?
Yes.
It wasn't done to your knowledge in this case.
Correct.
I'll pass the witness.
No further questions and witnesses excused by speech.
No further questions, witnesses excused.
All right, the rule has been invoked. You're not allowed to discuss your testimony or view anything about this trial during the pendency of the case. All right.
So she testified about her findings and another person's findings, and apparently they chose to not test for stuff at all. Well, they did test for some stuff, but not all the possible stuff they could test for. Okay.
Thank you. I'll make sure you leave your microphone.
And former crime lab
State, call your next
thing,
witness.
Wong is still missing.
Sure.
Thank you.
All right, who is this person?
Yeah, that's
No idea who she is or how she is involved in this. I hope it's interesting at least.
If you raise your right hand, you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand. Make sure you keep your voice up so that members of the jury can hear. If you'll state your name and spell your last name, please.
Denise Serenid, SERENIL.
All right, state, you may proceed.
Thank you, Your Honor. Sir, it's Cernal.
Yes.
Can you just please tell the jury how are you currently employed?
I am employed with the city of San Antonio.
And where are you based out of?
I work at the San Antonio Police Department headquarters.
And what's your occupation?
I am a latent fingerprint examiner.
And how long have you been a latent fingerprint examiner?
8 years.
And I guess in the realms of fingerprinting or fingerprints or prints, how long have you been in that field?
I have 26 years experience.
We don't need her CV.
So then what we consider what your profession at times, you have latent cards that are presented. What do you mean by that?
There could be fingerprints and there could be.
And now I'm assuming that means that if you have an unknown print, you find 7 points on there. There's 18 latent print cards. From those 18, were you able to identify any of those to a known standard or known print?
Yes, I was.
And can you tell the jury out of those 18 total, how many were you able to compare and possibly identify an individual that made those prints?
Okay. My guess here is they found fingerprints in a car, or the defendant's fingerprints in the car of his girlfriend. Nobody is surprised. She was his girlfriend.
May I have the evidence?
Do Do you have your report in front of you? Oh, sorry. I'm going to show you what's marked State Exhibit number 37. You can just look at that, been entered into evidence, and tell me if you recognize that.
Yes, I did.
And how do you recognize that?
I received it on April 24th, 2017.
And did you review it?
Yes, I did.
And can you tell me who collected this? Well, one, it's been entered into evidence. Can you hold up that card that's inside of this envelope? And can you turn it back and forth? And can you tell me, tell the jury, what is this?
This is an unknown prints that were lifted at this,
Sorry, go ahead.
at this particular scene.
And who was it lifted by?
This was lifted by crime scene investigator K. Wong, number 9440.
Okay, so it seems like this Miss Wong was the primary tester, and she's not around, so they have everybody in the office testify instead of her. They don't know how she did her work. They don't. If they want this evidence in, it should have been retested by new people, not people testifying about what another person did or didn't do.
And on this particular card, does it state where this fingerprint came from?
Yes, latent prints obtained from E4 Apple iPhone model number A1549 IMEI 356-99106-2443-296.
Thank you.
And Your Honor, at this time, we would request a hearing under 702 witness.
All right. All right, ladies and gentlemen.
Oh, they are having a hearing. Now that, having a hearing in this, now this can be interesting. Because outside of the ears of the jury, we will be able to hear stuff that would otherwise be not said.
I'm going to have you step outside. You heard some evidence in this case. You're not allowed to discuss with yourselves or with anyone else, do any research, or to begin deliberations. Does everyone understand? So I'm going to have you all step outside and I'll call you back in shortly. Everyone, please rise for the jurors. All right, everyone, please be seated. All right, defense.
Thank you, Your Honor. Good morning, ma'am. How are you?
I'm doing well, thank you.
Just a couple of questions. So I guess to start off with, in terms of the principle that no two people have the same fingerprint, I understand that. In terms of the idea of being able to examine the prints and say that it came from the same person each time, you mentioned that there are 7 points of comparison required for you to make identification, a positive identification of a print.
Correct.
What can you explain what you mean by the phrase points of identification?
They're the ridge characteristics.
Okay, what is a ridge characteristic?
It is an action point that one looks for, and there are different types of points that we look for in a print.
What makes the human finger develop those points? Do you know?
I do not.
Okay. Are they something that is developed by the human body as a natural process, or can points of comparison occur because of things that happen to the human body? Like
We are born with these prints.
okay, if I cut my finger, or I have damage to my finger, or I grow older and my skin changes, or I have a scar, do those things impact the way that those ridges on and points of comparison differ on a print?
It could, but the ridges do not change. They are permanent.
Okay, but they don't grow over scar tissue, for example.
No.
And so, I mean, what you're saying is there are some variables related to things not part of the human body or how it naturally grows and develops and so forth that could change or at least obscure the ridges that are naturally there on our fingers, correct?
Could be a scar.
Yeah. For a scar, for example, right?
Correct.
Now, when you're talking about these types of characteristics, how do they teach you to identify them?
We have to know the fingerprints, and we look at the specific point. We have to know what we are looking for, and there are several different characteristics that we do look for.
Okay, when you are developing those characteristics, are you in possession of the known point of comparison?
Not all the time.
But sometimes?
Yes.
In this case, were you?
No.
Okay.
All right, so here's my question. Are you challenging her as an expert? Are you challenging the scientific method of fingerprinting, or are you just doing a cross-examination?
I'm challenging the method of fingerprinting, Your Honor. I'm also going to be challenging the way in which the methodology was applied on the occasion in question.
All right, so that is cross-examination. If you're challenging that fingerprints are not scientific, then ask those questions. If you're challenging that she's not in the expert in the field of fingerprinting, then ask those questions. But everything else outside of that, that's cross-examination. So is that what's happening here? You're challenging her expertise?
Well, Your Honor, respectfully, I believe that under Daubert and Kelly, the purpose of this kind of a hearing authorizes me to ask questions about the underlying scientific theories.
Respectfully, I'm asking, are you challenging her ability as an expert? Are you saying she's not an expert in her field, or are you challenging and stating that fingerprints are not a part of the scientific method? They haven't been proven.
Judge Boyd is correct here. If they are challenging the methodology of fingerprint and fingerprint analysis, that is for cross-examination, and you bring your own expert on. Daubert is about, is she an expert?
And that I am assuming that there are fingerprints that can be the same from two different persons. What I'm trying to figure out from your questioning is, what is your challenge to this witness? If it's just for you to cross-examine, then that needs to be done in front of the jury. But if you're challenging her expertise and following Rule 701, 702, 703, then you need to have your questioning limited to 701, 702, 703.
Your Honor, as I was saying, I believe that to make the inquiry, the court must be apprised of what the scientific principle is, what the method used to apply that principle is, and whether that method was done correctly on this occasion.
Then respectfully, those are the questions that need to be asked.
Yes, Your Honor. I will try to
Thank
be
you.
more tailored to that. Your Honor, also just to streamline it, I'm also entitled under Rule 705 for disclosure of the underlying facts and data. So I would like to ask the witness a couple of questions about that because it will inform my inquiry and shorten it.
Well, haven't you already received that from the state?
Well, yes, but the record is entitled to be made all at the same
No,
time.
I understand that, but I'm trying to make sure that you have received that.
I am aware, I believe I've received it. I mean, I'd like to ask the witness
All right,
now.
proceed.
Okay, real quick, ma'am. You mentioned that you looked at a print that was taken off of a blue iPhone.
Apple iPhone,
Okay, and that was collected on what date?
April 23rd, 2017.
And that was collected by Kimberly Wong, correct?
Correct.
And then you also received a comparison print, right?
I received it from. Are you asking me if I had a known prints to compare to my unknown prints?
Were you asked to compare that print that was lifted off of the phone to a known print?
Yes.
Okay, and you're going to render an opinion about that comparison?
I analyzed the print, compared it to my unknown to my known, and determined they were one and the same.
Okay, and that print was from who?
This print was from Jalen Bell.
Okay. Okay. Okay, sorry. Your Honor, I'm going to withdraw the objection. I apologize. I misunderstood.
All right, bring the jurors in.
For some reason, I thought I saw the blue.
Okay. So, objection
I
withdrawn.
apologize.
Yeah. I should have been better prepared there, defense attorney. And there's 3 of you there. This shouldn't have been done. Skipping.
106. Can you
Okay.
clear just to rehash, just to make sure that we're on the same page? This was collected by Kimberly Wong on April 23rd, 2017.
That is correct.
And who was the individual that you were able to identify that made the prints on this particular cell phone?
I identified to Jalen Bell.
Thank you. I'm going to show you what's marked state exhibit number 106. Can you please look at that and tell me if you can identify that envelope and its contents?
Yes, I received it May 1st, 2017. There were 10 latent cards submitted.
And who were they submitted by?
They were submitted by crime scene investigator R. Hurtado, number 9414.
And did you have an opportunity to review those latent print cards, those 10 latent print cards, and were you able to identify, well, that's a compound question. Were you able to review those cards?
Yes, I was.
And on those possible cards, did you find any legible prints?
Yes, I did.
On those cards, legible prints, how many of those cards did you find legible prints on?
I found 2 cards with legible prints.
And I guess since we're on that subject, they're saying cards, and when I ask if it's legible, is that what you indicated earlier, that is a legible print, those 7 points that you have to find?
Correct.
So could there be partial prints on there?
There could be, yes.
And that under your qualification of a latent fingerprint or print examiner, you cannot determine a positive ID with less than 7 points.
That is correct.
But in this particular occasion, on 2 of those cards, you were able to identify legible print, and were you able to compare those prints to a known print?
Yes.
And were both of those latent cards that you have legible prints on, did that come back to the same individual?
Yes.
And please tell the jury who that individual is.
Jeremiah Rodriguez.
Thank you. Go to this time, the state would just enter state exhibit number 106. That's any objection. No objection.
States 106 is admitted without objection.
If you don't mind, can you take out the 2 cards that you identified that prints were made by Jeremiah Rodriguez? Can you please just hold those up and show them to the jury? And these are the prints that you identified coming to Jeremiah Rodriguez?
Yes.
Okay. And then on the front of those cards, it has a brief description of where they were found. Is that correct?
That is correct.
And previous testimony, Raul Hurtado, the individual that lifted those prints, is that correct? That's who collected those?
Yes.
And he explained where those were located.
Yes.
Thank you. You can put those back in here, please. Now, that's a total of Kimberly Wong turned in 1 latent print card, and then Mr. Raul Hurtado turned in 10. You said 18. Where are the other 7? Okay, you can, and it's not in the evidence yet, but on that particular one, were you able to identify any legible prints on those latent print cards?
I was not.
And how many latent print cards were turned in?
7 latent prints were submitted.
And who were they turned in by?
VH number 9418.
And so, as the purposes of evidentiary value, you cannot testify to those cards at all.
I cannot.
Now, we heard about a Jeremiah Rodriguez known prints. We've heard about Jalen Bell known prints. Were you asked to compare any and all these prints to other individuals?
Yes, I was.
And can you please tell the jury the other individuals that you compare these prints to?
Your Honor, may I get my notes?
Defense, she is asking to review her notes.
No objection.
Anybody?
Taymor McIntyre.
And anybody else that you compare these to?
So they found the fingerprints of Taymor McIntyre. It's his girlfriend's car. Of course, they're going to find fingerprints of him there. And the other guy, Yeah, he was in the car. But other than them three and some questionable eyewitness testimony, nobody else actually puts him in that car.
Joanna Reyes.
But the defense has more or less acknowledged he was in the car, so I don't think that matters.
Now, I'm stating that out of all these prints that you were able to determine that were legible, you identified one Jalen Bell and one to Jeremiah Rodriguez. Is that correct?
Correct.
Thank you, Mr. Nellis. We'll pass the witness.
No questions, Your Honor.
All right, is this witness excused or subject for recall?
You can state your honor.
The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this trial. Thank you.
Thank you.
Okay. Depending on who's the next witness. Now, if this is one of the people in the car, then that will take a long time. And we will save that until tomorrow. If it is a technical witness, like this one, we might as well get it over with.
And if you'll just leave the exhibits with the court reporter.
And sometimes even technical witnesses are really interesting, especially if sometimes they screw up or say something they shouldn't. Don't think it will happen here, but who knows?
All right, state, call your next witness.
The state calls Lindsay Patton.
Okay.
Can you raise your right hand? Can you raise your right hand?
She looks
Do you
like
solemnly swear or affirm the testimony you give will be the
technical
truth and nothing but
witness.
the truth, so help you God?
Yes.
All right, you can lower your hand. Or you make sure you keep your voice up so members of the jury can hear. And if you can state your name and spell your last name, please.
My name is Lindsay Patton. Last name spelled Patten.
All right, state, you may proceed.
Ms. Patton, how are you currently employed?
I currently work for the San Antonio Police Department.
And what unit are you with currently?
I am with the Southwest Texas Fusion Center.
What are your duties in your current role?
In my current role, I manage 6 grants for the unit, as well as purchasing and other budget items.
Okay. In total, how long have you been with the San Antonio Police Department?
17 years.
Okay. And were you previously assigned to the crime scene investigation unit?
Yes, I was.
About how long did you spend in that unit?
13 years.
Okay. What were your duties as a crime scene investigator?
I would collect evidence, take photographs, take fingerprints, things like that.
Okay. And what kind of training did you undergo to become a crime scene investigator?
When I was first hired, we get 3
we
months
don't
of
need
training.
the CV.
To extract associated with the case that we're here for today.
Could I see my extraction report?
Okay. Extraction report.
I have a print out of it. I forgot. I'll show you what has been marked as physical. Do you recognize what this is?
Yes.
Okay, and have you reviewed that before?
Yes, I have.
Does it contain a fair and accurate depiction of the extraction that was generated?
Yes, it does.
Okay, and that was for Kate. And do you have any unique identifiers on here to confirm that you reviewed the contents of the disc?
Yes, my initials are on it.
Okay, and so you recall that you reviewed it, correct?
Yes.
And it's fair and accurate copy of the report,
Yes.
and that analysis is in this case, correct?
Yes.
Okay. Can you tell the jury how you came into possession of the cellular device that you conducted the extraction on?
Sure. We have a secure lockbox in our photo lab, which is at our headquarters. And that day I took the piece of evidence out of the secure lockbox and I started to process it.
What did you search the exhibit number 140 under? What authority did you act?
There was a search warrant.
Okay. And what program did you use to conduct the forensic extraction?
It's called Cellbrite.
And did you have training experience with Cellbrite back in 2017?
Yes, I was trained by another CSI.
Okay, and had you conducted investigations previously with forensic devices using Cellebrite?
Yes,
And at the time, were you familiar with Cellebrite?
yes, I was familiar.
And in your training and experience, did you find it to be reliable?
Yes.
Can you explain to the jury how Cellebrite was used in this case regarding the
Cellebrite works in the way that if the prosecution believes it is in favor of their case, it is the absolute most reliable thing that has ever been created in humankind. If they believe it's not in favor of their case, it will not be as reliable.
contents of State's Exhibit 140?
Sure. At the time, had the phone, you would plug it into it's called a UFED device, a Universal Forensic Extraction Device. And that device plugs into the computer that has the Cellebrite software on it. So you would take the phone, plug it into the UFED, which gave you some prompts, and you would go through the prompts, and then the extraction report would run. And you just kind of waited. It would depend on how much data was on the phone as to how long it would take.
Okay. And so in this case, regarding State's Exhibit number 140, did you hook up the phone that you received to the Cellebrite toggle?
Yes.
Okay. And you followed all the prompts?
Yes, I did.
All right. And did a successful extraction occur?
Yes, I did.
And was a report generated with the findings of the cell phone that you received?
Yes.
Okay. To your knowledge, can the data that's extracted be manipulated in any way?
No.
Okay. And so, well, at this time, the state offers State's Exhibit 140.
No new objection.
All right. State's Exhibit number 140 is admitted.
Permission to publish.
Granted.
All right. Can you see that up there?
Yes. Yes.
Okay. Now, if you take a look at State's Exhibit number 140, what day was the report created?
It was created on June 6th of 2017.
Okay. And regarding the examiner name, who is that?
That's me.
Okay. And is that your badge number?
Yes, it was.
Now, regarding the extraction start date and time, can you tell the jury what that was?
The start date was June 6, 2017 at 8:29 a.m. And the end time was June 6th of 2017 at 8:32 a.m.
Now, regarding the MSISDN, can you explain to the jury what that is?
That is the full phone number of the device.
Okay. And regarding the detected phone model, can you please go over that with the jury?
It's an iPhone 5.
And who is the owner name that was designated to the device?
It's TAYK4 7 iPhone.
Okay. And what is the IMEI number registered to the phone?
The IMEI number, cellular device, it's assigned to every cellular device for the SIM slot.
Okay. And what was...
If you're wondering why the sound was cut off, is because Judge Boyd, when she can, will mute when a phone number is being told, which is good. We have no use for that.
In this case, on State's Exhibit 140.
It is 35. It's 3585 3805 63
And regarding the Apple IDs that were registered to the device, can you explain to the jury what those are?
They are emails, the first being SONOFSAAAM at AOL.com,
and the other being TAYK47U@iCloud.com.
And regarding call logs, you just give me a second. You previously reviewed this, and this is a fair and accurate depiction of the calls that were contained on the device, correct?
Yes.
And regarding this iMessage, can you explain to the jury regarding the item listed as 67, who the participants in that iMessage thread were?
It's going to be TAYK47U@iCloud.com.
Okay, and the other number associated with the text thread?
The other number is 1-469-347-3233.
And regarding this message on February 3rd of 2017 at 2:56 p.m., who does it appear sent that message?
The TAYK47U@iCloud.com.
And what does that message say?
It says, "Who is this?"
Okay, and then regarding the message sent directly after that, on February 3rd of 2017 at 2:57 p.m., can you say what number was associated with that chat?
It's 1-469-347-3233.
And what does that say?
Pimpy Z.
Okay. And regarding the message on February 3rd of 2017 at 2:57, is that an image that was sent to the iPhone?
Yes.
Okay.
There we go. All right, thanks.
All right, Ms. Patton, and as part of the reviews of cases in under 140, there were multiple images that were contained within the phone. Is that correct?
Yes, that's correct.
Hey, running on caffeine. No idea of details of this trial. Elevator pitch is Mr. McIntyre is charged with capital murder. He is, the prosecution claim, he is the shooter of Mr. The name I keep forgetting, Mr. Saldivar. So far during this trial, we have heard from one of the snitches and a bunch of eyewitnesses and a bunch of technical testimony as here. And all this is from 2017. Now there are 3 snitches in this trial. One of them have already been testifying. It's the cocaine stripper. And it's interesting, to say the least. And because everybody's pointing the finger at Mr. McIntyre. But it seems like, in my opinion, that it was a setup. Utterly set up.
And just regarding this image for demonstrative purposes, regarding line 13, can you identify when that photo was taken?
It was taken on February 10th of 2017 at 5:02 p.m.
Okay, regarding Sue's exhibit, or the item listed as 140, can you tell when that image was created?
It was created on March 3rd, 2017 at 3:16 p.m.
Okay, and line 141?
It was taken on March 3rd, 2017 at 3:15 p.m.
And 142?
It was taken on March 3rd, 2017 at 3:15 p.m.
And 143?
Also on March 3rd, 2017 at 3:15 p.m.
And regarding line 144?
It was taken on March 3rd, 2017 at 3:14 p.m.
Line 145?
1:45?
Yeah.
That was taken on March 3rd, 2017 at 3:14 p.m.
Line 146.
It's taken on March 3rd, 2017 at 3:14 p.m.
Line 147.
It's taken on March 2nd, 2017 at 8:38 p.m.
And line 148.
Was taken on March 2nd, 2017 at 8:38 p.m.
And just, we've gone through this previously, correct?
Yes.
There are other images that are contained within the state's exhibit, correct?
Yes.
And you would be able to tell the date and time that they were taken by looking where, if you could show the jury, please.
Looking right here at created.
Where my mouse is toggling.
Yes,
Okay.
that's correct.
Thank you very much. We pass the witness, Your Honor.
Defense?
Good morning, ma'am. How are you?
I'm good, thank you.
So what we just looked at is the contents of what's called a logical extraction. Is that right?
Yes, I believe it's also a file system extraction.
Okay, and there are different grades of extraction, right?
Yes, that's correct.
And logical or file system is the lowest level, lowest tier of extraction, correct?
Yes, sir, that's correct.
So for example, it won't tell you what's in the deleted files or in the cache of different applications, right?
Yes, that is correct.
If you wanted to look at messages that were sent on platforms like Instagram or Snapchat, things like that, you wouldn't be able to access.
No, sir.
And what ultimately this kind of a logical extraction produces is a PDF of
That's
like
correct.
on the phone, right?
Yes, sir.
So it's not like we can go in with a mouse and click on Instagram and scroll through or things like that.
Right, not with this version.
And it wouldn't give us detailed GPS data either, right?
I don't know. Thank you.
You don't know one way or the other.
No, sir.
That wasn't something you were asked to look at in this case.
Right.
Okay. Yeah, in order to do a more thorough extraction, we would need what's called a UFED reader, right? No.
In this case, I believe a more thorough extraction would have required the passcode to the phone.
And then you would also need to do a full file system extraction.
Yes, sir.
Okay. And then you would need to have special software to actually interact with the contents from that full file system extraction, correct?
Yes, in 2017, Cellbrite did not have that technology.
Okay. And it's proprietary software, right? To
Yes.
Cellbrite?
Yes, sir.
So do you know how many thousands of dollars it costs to have that software at your disposal?
Objection relevant.
What's the relevancy?
To explain how complicated it is to get more information from a cell phone.
All right, objection is sustained.
Pass witness.
No further questions, and she's excused by the state judge.
Excused.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this case or do anything. Do you understand?
Yes, I do.
All right, thank you.
Thank
Make
you.
sure you leave your microphone behind, and if you'll leave the exhibit with the court reporter. State, call your next witness.
Yes, Your Honor, the state calls Detective Rule, Boyds.
Yes. All right, ladies and gentlemen, I'm being informed by both parties that this is going to be a lengthy witness potentially. But I'm going to give you all a break so everyone can use the facilities and then we'll come back. But I'll make sure that you do have a lunch break, but I want to make sure that we continue with this witness. Then after this witness, I anticipate giving you your lunch break at that time. Are you all okay with that? All right, so I'm going to have everyone back here. Is 11:10 enough time for you all? All right, remember my previous instructions. Everyone, please rise for the jurors.
All right, folks. Yeah, so next witness will be a lengthy one. So this is a good natural point to finish today's stream. I will return tomorrow morning, roughly 9:30-ish Eastern Standard Time, where we will go through the rest of the day and hopefully a bit of maybe even catch up. I don't know. But we are 4 hours in and I need to eat. Everybody, thank you for being here. Thank you for being here when cocaine stripper, the rest of the cross-examination. It was amazing. amazing to see the absolute fuster clock of a witness that was. And I highly recommend you watch that again, because if you go back and watch it again, look at her and her demeanor. Because her demeanor does not match the questions asked at all, in my opinion. But yeah, this trial will be highly entertaining with the next witness, I hope. But again, thank you for being here. Thank you to Dave for his super chat. Thank you to Sebastian Miller for being a member for 16 months. Thank you to Polly for gifted a membership. Thank you to Interesting for your super chat. Thank you to Brain Socks over at Rumble. Thank you for your generous Rumble rant. And I will see you all back here tomorrow. Have a good one. And remember, folks, hug your family. Unless your family's crap. Then screw them and give your love to the people who deserve it. And I'm going to redirect you to Valhalla Awaits and his baby goat stream. All right. See you. Bye-bye.
Sail the raven waves, brothers. Axes high, shields